My lord, this is a very urgent matter, my lord, regarding issuance of non-creamy layer certificate. This is required for admission purpose and counseling is going on for medical admission in medical course, my lord. And it has already been numbered, my lord. May be taken up tomorrow, my lord.
But you mentioned before the appropriate bench.
This is bench 5 matter, my lord. Yesterday I went to mention before bench 3, my lord,
Hmm.
and I was told that this is bench 5 matter.
You please check it up because if it is in the wrong bench, then even if it is listed, the court will not take up.
My lord,
Why do you say this is bench 5 matter?
My lord, I have been told in
Which
court number 3, court number 3, my lord. 3 as well as 4. I also approached bench 4, my lord.
You send it to register judicial, ask him to sort it out and list it before appropriate bench.
Lordship, I beg to mention a matter for listing tomorrow.
What
It's,
matter?
I have been running a tea stall at Guwahati railway station and have been directed to vacate the tea stall. So
Directed to
to
vacate by
the-
when?
Actually, that operation of that impugned order has already taken effect, but I had moved an interlocutory application was interimly protected till tomorrow. That
Hmm.
interim order is till tomorrow. Then
There is
we have-
already a proceeding pending.
Yes, Lordship, an interlocutory application, but we have now filed a substantive writ petition. So if that in the substantive writ petition, if we get the order, we'll,
But if there is already a proceeding pending, why are you filing a new one?
no, my lord, actually a fresh cause of action had arisen and I had filed an interlocutory application just to take a interim protection on that day. itself.
Yes, subject to maintainability.
Yes,
You have to
Lord.
satisfy the court
Yes, Lord.
that both proceedings are maintainable.
Yes, Lord.
May it please, your lords. So I have experienced on item number 3. Lordship.
Yes.
So we required to file an additional affidavit, Lordship, but could not
On
file.
the
Lordship.
pair of learned, Mr. R. Fukan, learned counsel for the petitioner, this matter stands adjourned for a week.
May please, your lordship. Lordship, I beg to mention item number 7 of the daily list, my lord.
Hmm.
In this matter, we have been newly engaged, my lord. We'll file a wakalat number tomorrow. May I pay the matter may be taken up next week, my lord, or after
Item number 7, you are appearing for whom?
for the petitioner, my lord.
Mr. Todi is not there.
No, no, we have been newly engaged, my lord.
Achha, you're Mr.
RB Guhai, my lord.
Mr. R.B. Gohain, learned counsel has appeared and submits that he has been recently engaged in this case on behalf of the petitioner and will file the wakalatnama within
By tomorrow, my lord.
wakalatnama by tomorrow. As such, subject to presenting of duly executed wakalatnama by the petitioner, let this matter be listed again for motion by reflecting the name of learned counsel for the petitioner.
Highly obliged.
May I please, Lordship. Lordship, I beg to mention item number 30.
30.
We'll file an additional affidavit, my lord. So matter may be taken after 1 week.
Eh?
We'll file an additional affidavit, my lord.
You are mentioning item number?
30.
What is the case number?
My lord. 639.
You have informed the other side?
My lord, I'm but the petitioner, my lord.
No, then you let the matter be called up.
May I please, your lordship?
Yes.
My lord, I have filed one writ petition on C8, my lord.
Hmm.
It has not been listed, so may I pray for listing on Wednesday
What is the
for
matter?
motion?
What is the matter?
Fishery matter, man.
Fishery is not discussed.
Oh, sorry.
Lordship, I beg to mention item number 2. Lordship, my senior, she is not in station
As
today.
paid for by petitioner's counsel, this matter stands passed over for the day. Yes.
May it please, lordship. I beg to mention item number 9, my lord. It will listed after a week, my lord. I am for the
On the
petitioner.
prayer of Mr. A.B. Day, learned counsel for the petitioner, this matter stands passed over and shall now be listed again after a week. Yes.
May it please, your lordship. Lord, I beg to mention item number 29, my lord. Here, my lord, learned senior counsel, B. Datta, he will appear, my lord. He's on his way, my lord. May I pray that matter be taken up at 2, my lord.
That I can't say. When it is called up, we'll
Yes,
see.
my lord. At the obligation.
May I please, your lordship?
My lord, I beg to mention item number 35, my lord, with the consent of the others, my lord, may pay for passable for a day. 35.
On the prayer of Mr. D. Gogoi, learned counsel for the petitioner, this matter stands adjourned for 2 weeks.
For a day,
Stands passed over for the day.
my lord. Highly honest.
Lordship, I beg to mention item number 5. With due consent of the other side, this matter will be taken up in some other day.
You are appearing for
petitioner Lordship.
on the prayer of Miss
And Shyam.
N. Shyam Lal, counsel for the petitioner made with the consent of the other side. This matter stands passed over for the day.
My lord, a day may be fixed in this item number 5.
It will come, motion matter it will come.
May I please your lordship. Lordship, I beg to mention WPC number 5125 of 2022 and lordship 5364 of 2022 lordship for listing lordship.
Why?
The matter was last posted on lordship 10/8/2022. Matter regarding ex gratia.
Huh?
Ex gratia regarding.
You make an application to the register. Make a request to list it.
The petitioner prayed for the special police investigation, my lord, but already the case is succeeded. But only my humble prayer is that in the as per the report, my lord, one Zahirul Islam, his father is Hazrat Sahajat is not, he is a name accused, but it is not included in the search sheet. And the as per report, there is every possibility of supplementary search sheet, my lord. So
These
this
things
may be reflected, my lord, only that.
You approach the authority for
My
the
lord.
appropriate prayer. Take them heard Mr. DCC Fukan Council appearing for the writ petitioner. Also heard Mr. N. Goswami, learned Government Advocate Assam appearing for the state. Wisdom. This writ petition was instituted with a prayer to issue a direction upon the respond numbers 1 to 3 to carry out proper investigation in connection with Bilasipara Police Station case number 265 of the 2022, registered under sections 447/427/325/326/34,
303,
along with
303.
section 302 of the IPC through a special investigation agency. Today, when the matter is called up, Mr. Fukan submits that during the pendency of the writ petition, charge sheet has been submitted by the police. However, it is the submission of Mr. Fukan that although the father of the main accused, namely
Zahirul Islam,
Zahirul Islam,
son of Sahadat Ali.
son of Sahadat Ali,
Sahadat Ali.
was named in the FIR.
Yes, his name in
Yet
that.
he has not been sent up for trial. First up, Mr. Goswami, learned Government Advocate Assam submits that there is scope for filing supplementary charge sheet and therefore the petitioner may approach the appropriate authority raising the aforesaid grievance.
In our instruction dated 2/3/2023, that they have informed us that there is a possibility of filing of supplementary charges.
Yes.
If in the meantime filed also, maybe.
First up, Mr. Fukan has agreed to such a request. In view of the above, this writ petition stands closed at the stage of motion hearing by providing that the petitioner will be at liberty to agitate his grievance before the appropriate authority in accordance with law. It's advice.
Man, obliged.
His lordship.
Yes,
My lord, page 19 is the my lord order challenge in petition lordship.
order challenging.
My lord, page 19. This is the my lord order passed by the learned member, my lord, MSCT lordship. The petitioner approached the learned member MCT lordship for my lord withdrawal of the fixed deposited amount on the ground that the is
It is a bench for matter. It has to go there. For Mr. M.H. Ahmed, learned counsel for the petitioner. There is the amendments made in the writ petition. That is to verify whether this matter pertains to civil bench 4/5 and thereafter list the case before the appropriate bench. Mr. N. Goswami, learned Government Advocate Assam is present on behalf of the state, on behalf of the respondent number. These are all, you don't have the list. Every day we'll keep passing these orders.
sorry, Lord.
Yes, yes.
Item 6.
May please your lordship, the writ petition has been filed against the illegal unlawful construction of the private land, in the school campus lordships, the Jalajivan under Jalajivan mission lordship, permanent construction.
You approach the civil court. These are not subject matters of writ petition. Heard Mr.
Yeah, no,
N. Ahmed, learned counsel for the writ petitioner. Also heard Mr. N. Goswami, learned government advocate Assam, appearing for the respond numbers.
And for three, Lordship.
Appearing for the respond number 3. By filing this writ petition, a prayer has been made to restrain the respondent number 6
yes, sir.
from carrying out, from raising permanent construction over the land allotted to the petitioner, that is Balajan Abdul Hakim Girls ME Madrasa. Mr. Ahmed has fairly submitted that the construction is being raised over a private
Land.
patta land by a individual. If that be so, this court is of the opinion that this is not a matter which can be adjudicated in a writ petition. As such, by granting liberty to the petitioner to approach the civil court by filing appropriate by instituting appropriate proceeding, this matter stands closed. Full stop. Needless to say, disposal of this writ petition by this court shall not be a bar for the learned civil court to consider the matter on its own merit and pass interim order if so required. Writ petition stands disposed of.
Head, please, Lord.
Yes.
My lord, it may come after 2 weeks, man.
After
2 weeks.
on the prayer of Mr. So-and-so, Mr. Sheikh, Mr. Sheikh, and counsel for the petitioner, this matter stands adjourned for 2 weeks. List accordingly.
May I have Lordship?
Yes,
Lordship, my vehicle and 20 number T locks, Lordship, seized by the Division of Forest Officer, Karbi Anglong, Lordship,
Hmm.
on 17/3/2023, Lordship.
Hmm.
So here, Lordship, the genuinely T locks, Lordship.
Hmm.
After the harvest my own plot of land, Lordship. The on a tip of the Division Forest Officer.
so what is the order you are seeking here?
Lordship, I have submitted on representation, Lordship.
Hmm. What is the where is the representation?
Page 24, Lordship.
Page 24.
Finally, Lordship, page 24. In 1985, some second paragraph, Lordship.
So what, the logs have been seized along with the vehicle?
Yes, Lordship. Yes, Lordship.
Who is the vehicle owner?
Vehicle or I'm so yeah. These are petition number 1, Lordship. Junadul Islam, Lordship. Is a Tata Jodha, Lordship. Bearing number is 02 CC 80338, Lordship.
May please, your lordship. Lordship, we have not been served for copy, lordship, as yet.
We'll ask the authority to consider its representation and pass it.
Lordship, but
Yeah.
copy has not been served and we don't know
Will you
what is
serve
the
the copy
measure.
during the course
So
of the
since
day?
last-
I'll
Yes.
pass an order disposing
Sure.
it of. Heard Mr. R.C. Das, learned counsel appearing for the writ petitioner. Also heard Miss S. Kemprai, learned standing counsel, AAC, appearing for the respond numbers. Respond number 3 and Miss
3, Lordship.
Sabina Ahmed Upor Vidyabu. Learned SC Forest Department has appeared for respond numbers 1 and 2. Full stop. The petitioner number 1 is the owner of a
Tata Jodha, Lordship.
Tata
Jodha.
Yodha
Yes, Lordship.
vehicle, YODHA vehicle bearing registration number AS-02-CC-8038.
Yes,
And the
Lordship.
petitioner number 2 claims to be the owner of 20 numbers of teak plant, which were seized by the forest departmental authorities on 17/3/2023. Full stop. According to the petitioner number 2, the plantations were raised over his private patta land, and the same, and therefore there was no restriction or permit required to remove the said teak plantation by engaging a vehicle. Notwithstanding the same, and without considering the factual background of the case, the authorities have arbitrarily seized the vehicle along with the logs of teak plantation, thus causing serious injury to the interest of the petitioner. Full stop. Mr. Das has invited the attention of this court to the representation dated, no date, no date of representation.
So, yeah, that is 24/2023, Lordship.
Where does one find it? Where does one find it?
Before Divisional Forest Officer, Lordship.
Mr.
Emily.
Das further submits that his clients have submitted representation before the concerned DFO, raising grievance in the matter, but no action has been taken on such representation till today. First up, Ms. Kemprai, Leonard SC KAC submits that due to non-furnishing of extra copies, she could not obtain instruction in the matter. What is your stand?
But you will have to get instructions.
Ms. Shaheen also takes a similar stand in the matter. Full stop. Be that as it may, whether the plantations have been raised by the petitioner number 2 over his private patta land, and if so, whether the removal of the same by engaging the vehicle of the petitioner number 1 was in accordance with law is a matter which would require factual inquiry by the departmental authorities. It is only after a decision is taken in the matter that the writ court would be in a position to ascertain the validity of the impugned action. As such, although the learned departmental counsel have prayed for some more time to obtain instruction, I am of the view that keeping this writ petition pending would not serve any practical purpose. As such, the writ petition is disposed of by permitting the petitioner numbers 1 and 2 to submit separate representations before the respondent number 3 by enclosing a copy of this certified copy of this order, raising their grievance by furnishing the facts along with supporting documents. If such representation is filed within 10 days from today in the manner indicated herein above, the same be considered on merit and disposed of by a reasoned order within 3 weeks thereafter. Whatever be the decision of the respondent number 3, the same be communicated to the petitioners in writing. If the petitioners continue to remain aggrieved in the matter even thereafter, it will be open for them to approach this court once again by filing appropriate proceeding. The petition stands disposed of accordingly.
Sorry.
May it please your lordship.
Yes.
This case seeks a direction from your lordship in terms of the guidelines formulated by the Honorable Supreme Court of India in the case reported at 22 SCC online 905. Operative part lordship is at pages 25 and 26.
Where is your synopsis?
Lordship, a rather restrictive meaning was given at page 8 to the MTP Act, which has been now broadened by the Honorable Supreme Court in this case. And he seeks a direction from your lordship to terminate her pregnancy. She was a victim, lordship, of rape. To that effect, she had lodged the first information report.
Yes, what is your stand?
My view, Lordship, may
You please
direct
request
the-
Mr. Advocate General to be present in the court. Please request
As
you to
as
come.
there is a Supreme Court decision, Lordship.
Uh, Can you send a message to the AG? You wait for some time. Can come.
A medical board may be consulted.
Yes.
You inform the
I-
applicant.
yes,
and-
Lord.
May it please your lordship. So in this case, the petitioner is a registered NGO, your lordship, a government designated NGO, and they are running and managing a halfway home for mentally ill persons and persons with disability, your lordship. Now on 9/5/2023, your lordship, at Annexure 2, page 16, the local police handed over one person, suspected him to be a mentally ill person for the custody in the home of the petitioner NGO, your lordship. Page number 16. And he was in fact a drug addict person, your lordship. He was handed over on 9/5/2023 at page number 16 by the Maligram Town House Post to coordinator NGO Paradise Prayer for take care and shelter of the suspected mentally ill person. With due respect, I have the honor to report that I am sending here with the below noted person for favor of your kind shelter and care of him. He is suspected to be mentally ill. So on that night, at about 3 a.m. in the morning, he died, your lordship. He was basically a drug addict person, your lordship, and he committed severe shouting throughout the night. And in the night itself, he died. On the next morning, at page number 18, your lordship, the secretary informed the local police station that such and such person has died at page number 18, your lordship. And then, your lordship, an FIR was lodged on that very day, suspecting it to be a case of murder, your lordship. So one of the caretaker of the home was arrested. On the next day, police visited the place and sealed the whole campus of the NGO, your lordship. And they have taken away other inmates from there without giving any notice, without giving anything, your lordship. Thereafter, the petition has been moving that under what provision they have sealed the campus. For last 2.5 months, it is under lock and key, put by red tape mark, your lordship.
We'll issue notice, then they have to file their report.
Let them take an instruction and file, because, your lordship,
Huh?
any instruction as to why they have seized the.
That's what notice has to go. You are appearing. For whom?
For all the respondents.
And there is a
Mr. M.H. Laskar, Learned Counsel for the petitioner. The petitioner hearing is an NGO which is running a halfway home for the mentally ill person in the district of Kachar. Aggrieved by the action taken by the district administration, sealing the premises of the NGO on 11/5/2023 without serving prior notice upon the petitioner. The instant writ petition has been filed inter alia contending that the impugned action is not only arbitrary, but the same is also dehors the provision of law. Mr. Lashkar further submits that due to the above action of the authorities, several mentally ill persons who were earlier inmates of the NGO are suffering immensely. Hence this writ petition. Mr. S. Burwal, Learned Government Advocate Assam, appearing on behalf of the respondents, pray for some time to obtain instruction in the matter. In view of the above, issue notice of motion returnable on 8th of September 2023. Since Mr. Burwa has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the Learned Government Advocate Assam, requisite in numbers within 3 days from today, so as to enable him to obtain instruction facilitating disposal of the writ petition on the returnable date. First up, the respondents are directed to bring their stand on record by filing affidavit on or before the returnable date.
Pendency may not be a bar to, if they want to open. I have filed a representation.
Pendency of the writ petition shall not be a bar for the respondent authorities to redress the petition grievance of the petitioner in accordance with law if so advised.
I am deployed.
Right, Mr. Lawson, in this. Yes, my lord, the petitioner has submitted application before the respondent number 4, my lord, for issuance of a no objection certificate for selling the land in dispute, my lord. Although that deputy.
We'll have to issue notice here. Yes,
My lord.
heard Mr. M. Hussain, Learned Counsel for the writ
My lord,
petition.
one thing, my lord, consider, my lord, on 10/9, the DC permission will be expired, my lord. 10/9, my lord.
We'll fix it before that.
Yes, my
The petitioner has approached this court by filing the writ petition, being aggrieved by the inaction on the part of the respondent number 4 in his failure to issue the NOC for transfer of the land owned by the, who was petitioner is the owner of the land?
Yes, madam.
Owned by the petitioner, despite the fact that appropriate sale permission has already been issued by the concerned
Deputy.
authority, by the Deputy Commissioner of Dhubri District, full stop. Mr. Hussain submits that since the permission granted by the Deputy Commissioner for sale of the land is valid till 10/9/2023, there is urgency in the matter. Mr. S. Borua, learned government advocate, Assam, on the other hand, prays for some time to obtain instruction in the matter. In view of the above, issued notice of motion returnable on 30th of August. Since Mr. Borua has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned government advocate Assam within 2 days from today, so as to enable him to obtain instruction and file affidavit. In view of the urgency expressed in the matter, an attempt would be made to dispose of the writ petition on the returnable date. The learned government advocate Assam to obtain instruction accordingly. List again on 38/2020.
Of license.
Made please, your lordship. Your lordship, petitioner before your lordship is a doctor by profession, your lordship. And he along with his wife purchased a plot of land of about 5 katha by way of registered sale deed, which is mutated and it is in their possession, which is reflected at annexure 1, page number 12, your lordship. The said land is situated in Rangirkhari area, Rangirkhari point, your lordship.
So what they are going to demolish one pillar.
Yes, front side of the building, your lordship. They have put a red mark. They have not given any notice or whether my land is situated in the government land. That is also they are not clarifying. I have submitted a representation that please let me know, because as per my records, it is the whole land is a patta land, your lordship. There is no government land interest there. Now they want to widen the road and now they are saying that they will demolish front portion of the building, your lordship. But nothing has been given. Only that mark has been put after measuring the road, your lordship.
Where is your representation?
At page number 19, your lordship. I may read, your lordship. It has come to my knowledge that a team of staff of Circle Office Settlement of Ocean Silchar has surveyed and measured the width of the road of Rangirkhari Point Silchar yesterday morning on so and so, and then they have put red color marking on the pillars of my building named Biomet Square, located at the point of Sunai Road at Rangirkhari Point Silchar. Sir, I'd like to know why is this red mark putting on my ceiling, which shows 5 feet from the present footpath. Sir, for your information, I have got the occupancy certificate issued by the settlement officer after proper mutation, and the same was rechecked by bank and DFB before sanctioning of loan.
Yes, who is appearing for the respondents?
I'm paying for one lordship.
Yes, what about the others?
I pay for 2, 3, and 4. And notice has moved to the Silchar ministry.
No, we'll dispose it out. No, no.
Dispose of?
Let them answer his representation.
Yes.
Yes. Heard Mr. M.H. Lashkar and a counsel appearing for the writ petitioner. The petitioner herein claims to be a doctor by profession and is operating and is running a diagnostic center along with his wife, Srimati Dopati Pal, in a building by the name and style within quotes Biomed Square, unquote, situated over a plot of land measuring 5 kata 3 chataks, standing over tag numbers 617 and 618, tag numbers, covered by second RS Patta number 197 of Pargana Barakpar under Moja Ambikapur Part Roman 9
in Kachar district.
In Kachar district, commonly known as Rangirkhari, Rangirkhi, Rangirkhari Point. Full stop. As per the case projected in the writ petition, the aforesaid commercial complex was constructed after obtaining permission, obtaining proper construction permission, and also by maintaining and also by adhering to the building bylaws. Full stop. After occupation certificate was issued by the authorities, the petitioner uh, occupied the building, and since then he is running the aforesaid diagnostic center system. The grievance of the petitioner is that on 13/6/2023, some staff of the respondent number 2 had arrived at his commercial building and put a red cross mark on the front side of the building by indicating that a part of the building will be demolished in connection with
Widening of the-
expansion of the main road. Full stop. Mr. Lashkar submits that there is nothing to indicate that demolition of the building was required for expansion of the main road. Moreover, if the front side of the building is demolished, the entire structure will collapse, thereby depriving the petitioner of valuable property. Notwithstanding the same, the respondents are contemplating to demolish the building without serving any prior notice upon the petitioner or giving him an opportunity of being heard in the matter. The learned counsel for the petitioner has also submitted that on 14/6/2023, he had submitted a representation before the respondent number 3, bracket annexure Roman 6, bracket close, expressing his apprehension and grievance in the matter. However, despite receipt of the said representation, a copy of which was also marked to the respondent number 2, no action has been taken in the matter till date. Hence this repetition. Full stop. Mr. S. Borua, Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam, appearing for the respondent number 1, and Mr. S. Borua, learned Government Advocate, Assam, appearing for respondent numbers 2, 3, and 4, submit that they be granted some time to seek instruction in the matter. Full stop. As noted above, there is no complaint about the fact that the building of the petitioner was erected over his private patta land by obtaining proper permission. The only apprehension of the petitioner is with regards to the fact that if the front side of the building is demolished without serving any prior notice upon him and without considering his grievance in the matter, then the same would result into serious prejudice to his rights and interests. First step. There can be hardly any doubt about the fact that if a building is sought to be demolished for widening of road, the owner of the building would be entitled to appropriate notice wherein the necessary particulars, including the description of the land and the purpose for which the land stroke building is sought to be demolished, acquired or demolished, has to be properly reflected, and the owner would have to be given an opportunity to represent his case. Since the petitioner has categorically averred that no such procedure has been followed in this case, I am of the opinion that keeping the writ petition pending before this court at this stage would serve no practical purpose. As such, this writ petition is being disposed of at this stage of motion hearing by granting 2 weeks' time to the petitioner to submit a fresh representation before the respondent number 2 by expressing his grievance in the matter by enclosing a certified copy of this order. Full stop. If such a representation is submitted within 2 weeks from today, the respondent number 2 will look into the matter and, after considering the facts and circumstances of the case, communicate his decision to the petitioner in writing. Full stop. Until such time the aforesaid exercise is completed, status quo as regards the building of the petitioner shall be maintained. Full stop. if the petitioner continues to remain aggrieved even thereafter, it will be open for him to approach this court once again by filing appropriate.
Lordship, one more. In his representation that he has filed before the circle officer, so there he have categorically stated as regard two complaints which has been laws against the violation and encroachment upon government land. And he also says that a clean sheet has been given by the authority, but those documents are not before the court, so I am unable to
It is
answer.
there, it is there, your lordship.
Submit representation along with necessary supporting documents and enclosing a copy of this order, ventilating his grievance in the matter by also establishing that the building has been constructed by following
In
the-
accordance with law.
in accordance with law.
Obliged.
My lord, I'm putting. We have filed this stay vacating application. My lord, there is a status quo order in relation to the property. It was supposed to be sold under the Sarfisha Act. And my lord, the petitioner, my lord, was the highest, my lord, successful bidder. And after his bid was submitted, my lord, on the very evening prior to the auction, my lord, we received an order of injunction from the learned court of the Munsif number 2 of Kamrup M. My lord. And a case was filed, my lord, by some person claiming himself to be a tenant in the said property. And my lord, though we tried to cancel the auction in the due time, but because the auction is not conducted by us, it is conducted at Delhi by a third party. My lord. So the auction could not be cancelled at the last minute. And then, my lord, admittedly, they are the highest bidder. They submitted the 10% EMD amount also. My lord.
They means who?
The petitioner. The petitioner who is the bidder in the auction, because the sale was never completed because of the order in between passed by the learned court of the Munsif number 2. Now we immediately, my lord, approached the court of the learned Munsif number 2. We filed an application under Order 7 Rule 11 for rejection of the plaint. We did everything that we could in our power. However, my lords, when we finally found that no, my lord, the order of injunction is continuing, then we were forced to cancel the bid. My lords. Now the period between 29/6/2022, that is the date of the e-auction, and 23rd of November 2022. That is the period when, my lord, the auction, the petitioner, my lords, continued to be the bidder, but there was no additional amount offered, and nor did we ask for any because we couldn't, my lord, the auction couldn't be completed. So therefore, my lords, in other circumstances, the case, the continuation of this status quo order neither benefits him nor benefits us. My lord.
Which status? What is this?
My lord, the order of status quo, my lord, is dated 7/12/2022, passed by my lord Justice Surana. Lordship will kindly have, my lord.
Before that, my lord, if my friend can show the injunction order passed by the learned.
Yes, of course.
If it is annexed there. It's not annexed.
See my affidavit in opposition.
Court orders. It is good.
See the affidavit in opposition.
Where is the status quo?
Status quo dated 7/12/2022. my lords.
I don't see any word status quo here.
Yes, my lord, the cancellation of the, it shall not create, my lord, this part till the next returnable date, the respondent number 3 bank shall not create any third party interest over the said property that was put on auction on 29/6.
Yes.
So
So
third
what
party
what is the
interest-
problem with it? You have cancelled the.
I have cancelled, but my lord, until and unless this continues, now the proceeding before the land Munsif is a different issue. We are contesting that, my lord, perhaps it will be decided soon. But as far as this continues, my lord, we are unable to, my lord, negotiate either with any party or to put it for a fresh auction. So my lord, both cannot continue at the same time. And he also doesn't serve-
No right is created unless the sale is confirmed.
So lordship, that is correct.
So the auction itself has been cancelled.
That has been cancelled. And my lord, we have been ready from day one to return his amount, my lord, the 32 lakhs or that he has deposited.
So, Mr. Chamua, whatever you may say, you can't get the property through this process. There has to be a fresh auction, fresh.
If the auction is illegally cancelled, then my lord, my right
Even
is,
then, it is gone.
no, well, my right to
You
challenge
have
is
to-
that exists, my lord. Number one,
Hmm.
my learned friend has filed this IF for vacation of the interim order. That itself shows that they are interested to settle this matter with a third party. That is why this order creating a clog in that part. That itself shows. Number one. Number two, where is the injunction order they have annexed? They have not annexed the injunction order.
My affidavit in opposition is there.
No,
All the
this IA it's not there. IA it is not there, following which he has come before this court to vacate the
matter was
interim
taken up for
order.
disposal, then
No.
I am ready to.
My
argue.
lord will appreciate. They are the model agencies of this nation. They cannot do whatever they would like
No,
to
no, no,
do.
You see, that's not the point. That is not the point. Point is, once an auction sale is cancelled,
without any reason.
even if it is without any reason, I'll tell you a few things, you will be surprised. If an auction sale is confirmed, except for fraud, even if it is illegal, if the sale is set aside, the right to property cannot be, conferment of title cannot be interfered with. That's the law. If the sale is set aside, then also the person who acquires title, his title cannot be interfered, except if it is a case of fraud. Conversely, auction has to happen as per the notified date and time. For whatever reason, if it doesn't happen, they will have to conduct a fresh auction by a fresh notice.
It has happened. The auction was
That's the
happened.
law.
No, auction was taken place. I participated. I am the H1 breeder. I deposited the entire money, is whatever to be deposited. There is no dispute at all. One fine morning,
The
they said
reason
your
is
auction is
you-
cancelled.
You don't have any right as of now. Your protection is only under Article 14 against discrimination. If they give the bid to a second highest bidder by ignoring you, then you have a case. Otherwise, merely because the auction has happened, that does not create any right in your favor.
No, my lord,
Please
perhaps,
argue on this point and satisfy the court.
but my lord, they have not make out a case for cancellation or the vacation of the interim order, number one. Number two, the coming into the lower court, municipal court into this aspect is this, I'm surprising. How can the court below it's there? This order was obtained by misleading facts before the trial court.
No, they have filed the case.
No, they have not filed it. This is also a creation of that landowner. That we can understand. It's a different issue, but those things are not before your lordship. Number one. Number two, my lord, I sincerely submit before your lordship. If without assigning any reason, my auction, my highest bidding has been cancelled. And
So, Mr. Chamua, what is the relief you are seeking in the writ petition?
complete me 1 minute, my lord.
First, you tell me what is the relief?
My relief, I was praying before your lordship is that the bank should continue with the auction. I am ready to deposit the rest
We'll
amount.
take up the matter tomorrow. Get a judgment which permits such kind of a mandamus. We'll allow the writ petition.
That too in the teeth of the injunction order.
Once you can show that there is, cite a decision which says, once auction has been held or it has been wrongly cancelled, writ court will issue a mandamus directing them to settle it with the party. We'll allow the writ petition tomorrow itself.
Not exactly tomorrow, my lord. Give us 2-3 days time at least. Having some preoccupation, that is why. I will come up, my lord. I also want to know. Maybe the research is halfway. I'll come. I want to know, to go to the bottom of it.
What happens is this confirmation of sale, which is the provision in the CPC.
No, it's a confirmation of sale. Look, as far as the cancellation of sale is concerned, that would be under order 21. Those provisions are there, order rule 90.
Order
etc.
21, rule 90.
90 minutes. Those are related to that.
Check up
provisions.
those things.
Yes.
Only fraud and material irregularity has been time and time again.
Vis-a-vis the provisions of Sufficiency Act, my lord.
And that too in respect of a
If it
completed
is
sale.
arbitrarily cancelled, you don't have any right. Arbitrarily, no injunction. Suddenly they decide will not hold it. Then also you don't have any right. Let's take it that there is no order of injunction. Even then you can't. It is just like saying, if I participate in a selection process, you must appoint me. No such law.
That is not there, but.
But you will acquire a right. Once the sale is
Here the
confirmed.
situation is a little bit different, little bit going one step ahead of that situation.
That's right. So what I'm saying is, you may have a, you may have a case if you can prove or establish this,
Let me try, my lord.
that even if the auction is arbitrarily cancelled, arbitrarily, no order, no injunction order, or injunction order is not bona fide. They cancel the auction for no reason. You cannot get a mandamus from the court directing them to proceed with the auction. You cannot establish any such right. List again on Thursday on the request of Mr. S. H.
Can it be on a day after tomorrow, Thursday, or some other matter?
Then
Can it be
it
day
will go to
after?
next week,
Then Thursday.
Next
Thursday.
week,
Thursday.
This cannot be, 10.5 crores are hanging in the balance. Why does he is?
We are now on
he is
page-
there. No, he has no vested right. Where is his vested right?
Next matter, please.
My lordship, date.
Thursday.
Thursday means what?
10th.
10th.
Interim order passed earlier to continue till then.
Yeah, my lord, I am praying for 10 days time to file objection, my lord, against the interlocutory application filed by the respondent
Hmm.
for vacation of stay.
Where is the order? Where is
The
the
IA, my lord.
order? Mr.
Page
Khattaria,
22.
which place is the interim order? Page?
In page 22 in IA 1779, page 22, my lord. Order 31/8/2022, my lord.
You want time?
The date may be fixed.
After 10 days?
Date may be fixed.
Mr. R.J. Das, Learned Counsel is present on behalf of the applicant, Mr. N.J. Khattaria, Learned Counsel for the OP stroke read petitioner 6, 10 days time to file objection opposing the prayer made in the IS. Mr. S. Bora, Learned Standing Counsel.
GMDM, I have filed my affidavit.
GMBA submits that objection on behalf of his client is already on record. In view of the request made by Mr. Khattaria, this matter is directed to be listed again after 10 days as a fixed item. In the meantime, objection, if any, be brought on record by serving advance copy upon the applicant's counsel. So the
Well,
interim order passed earlier to continue until further orders.
Date. Obliged.
After 10 days, you count it. Sit there and count 10 days and tell me when the date is.
Obliged.
Yes. Count and tell me.
Today's 17.
Deeply obliged.
If you apply your mind, you will get the answer yourself. Yes.
Order no steps, item 16 and 17.
My lord, I have taken the text. In both the cases, I have
So
taken.
why are you giving it to the court? You will ask them to, you give it to the registry. Mr. P.K. Rajchandran and counsel for the petitioner submits that steps have been taken as per the order of this court. Mr. In view of the above, the proof of the same be furnished to the registry within 2 days from today. Let this matter be listed again after 10 days with appropriate note, office note. Miss
A Begum,
E. Begum, Learned Counsel is present on behalf of the
APP. Additional Public.
A. Begum, Learned APP. Assam is present.
My lord, the interim order to continue in both the cases. There are two cases. One is criminal petition and on writ petition.
Interim orders passed earlier to continue till the next listing.
I think the writ petition also the same order.
Next listing.
For admission, item 81.
May I please, your
In
lordship,
both the cases, steps have been taken. Both the same order.
may I please, your lordship, this writ petition has been filed for handing over the investigation to the CBI lordship. On the last occasion, they have taken time to obtain instruction as regard the status of the SIT which has been constituted.
We have got the seal cover report. In fact, the previous instruction was not so comprehensive, so lordship wanted to have a status as regard the investigation and that is going on. And
Why in seal cover?
that has been asked by the court to produce on the previous occasion.
Covers must be blown off, Mr. Borua. A time has come to remove all covers.
Yes, but since it's a criminal investigation, maybe some datas may not be in the public domain.
Yes. So what is the law for handing over investigation to the CBI?
Lordship, Lordship, Supreme Court judgment is there, Lordship, in 2007-8 Supreme 226, Lordship. It has been clearly stated that an investigation can be handed over.
the judgment?
Lordship.
So nothing has happened practically, some arrests, some suspicions.
Yes, in fact, previously we have filed an affidavit. So there the name of three accused, one, the person who has made a call threatening to kidnap, threatening not to participate in the no confidence motion. That person's name, number has been traced out. IMEF number has been tracked. And accordingly, voice samples has been taken of 5 suspected persons. And finally, they have come down to the conclusion that 3 persons are in the lookout and they have been absconding since 2016. That is what the previous affidavit report says. And now the present status, I don't know what exactly is inside it.
Where is the Ejahar?
I'm fine.
Page 15, Lordship.
Page?
15.
Take down heard Mr. B. Thompson, Nayak Counsel appearing for the Chief Minister. Also heard Mr. S. Barua, Learned Government Advocate Assam appearing for the for all the respondents.
Yes. Yes. But the CBI has been made a party here.
Appearing for the respondent numbers 1, 2, and 3. CBI's name has been
Lordship,
deleted.
it has been deleted.
Why it has been deleted?
Deleted.
Because SIT was constituted.
Ah.
That's why for the time being, court said it's not necessary. Because CBI counsel was appearing. But
SIT constituted by which order?
SIT was constituted by the government. Government has informed.
Recorded SIT posted.
I think order dated 1/8/22.
Who is heading the SIT?
SP. SP, I think Hapla. Right? SP of the district. Well, question is put this.
Nothing is not given to this. Yes, that was very big loss. So that's why.
Before the date, I can the someone number.
When 2016 petitioner's husband was 2016, January 2016, petitioner husband was kidnapped on political reasons. saying that if your brother does not abstain from voting, no confidence motion on a particular date, he will be killed. So thereafter, we filed the FIR, and thereafter, my lord, he is missing. In the additional affidavit, we have stated, my lord, that persons who are
The missing person is petitioner's husband.
husband, my lord.
And
He
who
was
said
kidnapped.
your brother, whose brother?
Complainant.
Complainant is
Complainant,
That is the informant.
yes,
Yes.
informant.
No, I'm not getting the order by which SIT has been constituted. What is the date of the order?
I mean, this was constituted by the government themselves, my lord, taking into consideration the progress made by the police. 1/8/22, your lordship has got it, my lord. 1/8/22.
So you want a CBI investigation?
CBI investigation.
Then the CBI has to be made a party here.
Well, it was made party, but because the council was saying since SIT is going on, I can make party agent. I can make party. But
No, we'll do it.
Well,
Why
I'll take
should
steps.
you take all the trouble now?
Since my lord, no my lord, satisfactory investigation, the lordship may direct. I'll give copy to them again.
But then you write Mr. B.D. Das, senior counsel, estate by Mr. D. Thousand, learned counsel appearing for the petitioner. So and so Mr. S. Barwa for rescue numbers 1, 2, and 3. Post office. Sri Mohendra Kamprai, the brother of Jivan Kamprai, had lodged an ejahat before the Dayangmukh police station, Dima Hasao district, Assam, on 28/1/2016, reporting the kidnapping of his brother Jivan Kamprai at Jongshore, JONGSHORHADI village by some unidentified miscreants / antisocial elements. The FIR mentions that the kidnappers had threatened Jivan Kamprai to abstain from attending the emergent session of the NC Hills Autonomous Council to be held on 29 January 2016, as otherwise you would face dire consequences. In the emergent session of 29/01/2016, a no confidence motion was to be moved against the executives in power in the Autonomous Council. Based on the ejahat dated so and so 28/1/2016, Dayangmukh PS case number 03/2016 had been registered under section 365, read with section 506/34 of the IPC, and the police had started investigation in the matter. Since the whereabouts of the victim could not be ascertained by the police and no accused and charge sheet could not be submitted in the police case against the accused, the wife of the missing person had approached this court by filing the instant writ petition, seeking a direction from this court to hand over the investigation in the case to the Central Bureau of Investigation, which was originally imputed as respondent number 4 in this writ petition. First up, during the pendency of the writ petition, this court was informed that a 3-member special investigation team (SIT) headed by the Superintendent of Police Dima Hasao had taken over the investigation. In view of the above, the name of the respondent number 4 (CBI) was struck off on the arrow parties by order dated 6/9/2022 by giving liberty to the petitioner to add the said respondent number 4 once again, as and when the occasion arises. On 19/7/2013, this court had granted 2 weeks' time to the learned State Council to produce a status report of the investigation in a seal cover in terms of the earlier order dated 02/06/2023. Accordingly, a status report dated 3/8/2023 issued by the Superintendent of Police, Dimahasa District, Haflong, has been produced before this court today in a seal cover. I have perused the same. It appears that save and except arresting a few suspects and recording the statements of a few witnesses, the police could not submit, the SIT could not conclude the investigation. As a result of it, no charge sheet has been submitted in connection with Diangmuk PS case number 03/2016 till today. Full stop. Moreover, the victim remains untraced even after 7 years since the date on which he went missing. Full stop. It is in this factual backdrop that this court is called upon to consider the prayer made by the petitioner to hand over the investigation to the CBI. Full stop. By placing reliance on a decision of the Supreme Court in the case of Sakiri Basu, SAKIRI Basu, VASC, versus State of UP and others, reported in 2007, bracket 8 SCC 226. Mr. Das submits that the present is a fit case where the investigation should be handed over to the CBI. First up, before considering the said prayer, this court is of the opinion that the CBI must be heard in the matter. First up, as such, the original respondent number 4, that is the CBI, is hereby restored back in the file. The order dated 6/9/2022 stands modified, passed by this court earlier, stands modified to the above extent. Registry to list this matter again after 3 weeks by reflecting the name of learned DSGI in the cause list as the counsel for the respondent number 4. First up, in the meantime, a copy of this order as well as the writ petition be furnished to the learned DSGI by the registry. First up, the report dated 3/8/2023 be retained in seal cover along with the record of this case. First up, let the matter be listed accordingly. Let us hear them. Then we'll.
No, date may be given 3 weeks.
3 weeks will come after 3 weeks. Put it back in seal cover. Yes, call that matter.
Obliged.
Mr. Saikia, sorry to trouble you.
No, it's okay.
See, this is a very sensitive matter. You've
Lord.
seen it. What is to be done?
Lordship, maybe, yes. I do not know exactly what is the stage of pregnancy now, whether it is, if it is under 24 weeks, then under section 3B, women ineligible for termination of pregnancy up to 24 weeks, survivor of sexual assault, rape, incest. So if it is below 24 weeks, then there is no difficulty. A medical board has to be constituted under section 2C. 3(2)(c), medical board shall consider the following: gynecologist, pediatrician, radiologist, or sonologist, and any other member as may be notified by the office gazette of the state government. Page 18. I am just referring to some quotation of the law in an honorable Supreme Court judgment. Paragraph 9, page 18. In what situations pregnancy can be terminated, Lordship? Under the MTP Act.
Paragraph 9.
Paragraph 9.
Section 3 is. quoted.
Section 3 is quoted there. 2 small a. So I am reading section 3. When pregnancy may be terminated by registered medical practitioners, 2 says, subject to the provisions of subsection 4, a pregnancy may be terminated by a registered medical practitioner where the length of pregnancy does not exceed 20 weeks in such medical case. This is number 1. If Lordship is pleased to come to paragraph 12, 3B,
Yes,
Page 19.
page 19, paragraph 12.
yes.
3B of the MTP rules has been made in pursuance of the provisions of clause 4 of subsection 2 of section 3 of the MTP Act. 3B is as follows. Women eligible for termination of pregnancy up to 24. Here, 4 weeks are added. The following categories of women shall be considered eligible for termination of the pregnancy under clause B of subsection 2 of section 3 for a period up to 24 weeks, namely A, survivor of sexual assault, rape and incest. So in this case, I think there is sexual molestation and all. So there is a FIR also, but it has not been clear what was the date of rape.
She is in the 17th week, Lordship. No.
So she should be subjected to examination. by
Exactly.
medical-
This medical board has to be constituted. They will examine, they will see whether it is possible or whether what is the length of pregnancy. Thereafter, a recognized medical practitioner under the government hospital, they can do. In this case, Lordship, the direction was at page identical situation more or less, paragraph 26, page 22. In the above background, we passed the following ad interim order. We requested the director of All India Medical Institute of Science, Delhi, to constitute a medical board in terms of the provisions of section so and so. Then 2, in the event the medical board concludes that the fetus can be aborted without danger to the life of the petitioner, a team of doctors of AIMS shall carry out the abortion in terms of the request which has been made before the High Court and which was reiterated both in the special leave petition and the course of submission before this court by counsels appearing on behalf of the petitioner. Before doing so, the wishes of the petitioner shall be ascertained again and her written consent obtained after due verification of identity. Then the report has to be submitted with the honorable court. So I think there is no difficulty on that if whatever they are stating is correct.
So we'll ask the superintendent.
Superintendent
GMC.
Guwahati Medical College to constitute the board as per this act and rules. And thereafter, whatever findings they get, then the consequential action may be taken.
And she can appear within 1 week
Yes, Lordship.
because there's time is a
Time
factor here.
is crucial.
You heard, take down, heard Miss B. Chaudhary, learned counsel appearing, learned legal aid counsel appearing for the petitioner. The read petitioner hearing is a rape victim. Rape victim. She has approached this court seeking permission for medical termination of her pregnancy through registered medical practitioner. Now, before that, you write, as a fallout of the incident of rape, the petitioner has become pregnant. Full stop. She has approached this court by filing the instant writ petition, seeking permission to terminate her pregnancy with the assistance of registered medical practitioner at any government or private approved center or hospital. Full stop. By referring to the provisions of the Medical Termination of Pregnancy Act, 1971, as well as the guidelines laid down in the decision of the Honorable Supreme Court in the matter of X-petitioner versus Principal Secretary, Health and Family Welfare Department and another respondents reported in 2022 SCC online SC 905. This will be in page 17 of the petition. Ms. Chaudhary submits that since her client is in the 17th week of pregnancy, a medical board be constituted to examine her condition and thereafter appropriate steps for medical termination of the pregnancy be taken without any further delay. Full stop. Considering the sensitive nature of issue involved in this case, the court had requested Mr. D. Saika, learned Advocate General Assam, to assist the court in the matter. Full stop. Mr. Saikia on due examination of the writ petition and the due examination of these averments made in the writ petition and as well as the guidelines laid down by the Honorable Supreme Court submits that if a direction is issued by the court, a medical board will be constituted under the aegis of the superintendent or principal?
Superintendent.
Superintendent of the Guwahati Medical College Hospital, which can examine the condition of the petitioner.
Let it be the chief superintendent come principal Guwahati Medical
Chief
College.
Superintendent come Principal Guwahati Medical College Hospital, which will examine the condition of the petitioner before taking a decision in the matter. The learned AG has however fairly submitted that considering the facts and circumstances of the case and in view of the guidelines laid down by the Honorable Supreme Court in the above decision, medical termination of pregnancy, subject to fitness of the petitioner, would be permissible if the pregnancy has not exceeded 24 weeks. Full stop. Taking note of the facts of the case and the submission made by the learned Advocate General Assam, it is therefore directed that a medical board be constituted by the under the supervision of the Chief Superintendent and medical principal of the Guwahati Medical College Hospital. Then how do we operate it?
Medical board as per the provisions of this MRTP rules.
As per the provisions of section 3, is it 3?
No, 2D.
Section
Lordship, it
2D.
is 3, capital, the big 3, then within bracket 2, capital D. The
At
page 18,
22.
Yes.
page 18. it
As
is-
per the provisions of section 3, bracket numerical 2,
D, capital D.
bracket
Capital D.
capital, sorry,
2, capital
capital
D,
D.
within bracket. 3, within bracket 2, then capital D.
correct. 3, bracket 2, then capital D of the
MRP Act, section 3 of MRP Act.
MRP of or MTP.
MTP.
MTP Act, 1971. The petitioner to appear before the board for the requisite medical examination. The exercise be carried out
Within 1 week, Lordship.
within 1 week from today, and a report be placed before this court for awaiting further order in the matter. Let this writ petition be listed again on next Monday as a fixed item by.
Next Monday will be exactly 1 week, so let it be next Wednesday, if it is not a holiday. Yes, 16th is not an holiday. Let it be on 16th.
Want it on 16, but time factor will be there.
Time factor, then let them come, not 7 days, 5 days. In that case, Monday is okay.
Within 5 days from today. Then how will they know when to come?
So the council will communicate.
Will you, Mr. DP Bora,
From our side, we'll cooperate with her.
Will inform the
Mr. DP Bora, Learned Standing Council, Health and Family Welfare Department, Assam, to inform Ms. B. Chaudhary in writing the date and time when the petitioner would be required to appear before the medical board. That will come
And
on
we'll
Monday.
coordinate with the learned council.
Sweet Lordship.
Highly
Much
obliged.
obliged.
Will come on 14th, list again on 14th.
Lordship, kindly pass over a matter for the time being also. My senior election code number 7.
What is this matter about?
Regarding my lord, non-payment of bill, my lord, and we have filed,
Contractual bill.
yes, my lord, and
These are not bench file matters. Why they have listed in bench file? They are doing it in a very haphazard manner. Let it go for the appropriate bench.
yes, my lord.
This matter pertains to non-payment of contractual dues, which appears to be a subject matter of civil bench 4. Register to verify and list the matter before the appropriate.
Obliged.
Much obliged. Lordship.
Not list before any other bench without meeting. Another.
Matter regards to non-payment of contractual settlement.
Same order. Bench for civil bench, non-payment of.
My lord, this is the case, my lord, where the dispute arises between the, my lord, read petitioner and private respondent regarding holding of charge of in-charge secretary, my lord. And during the pendency of the read petition, some development has taken place, my lord. An appeal was referred by the, my lord, respondents, and in that appeal, an order was passed to appoint one-man committee. Accordingly, one-man committee was appointed, and a one-man committee is going to hold the AGM election, my lord. So my lord, submission is that, my lord, at this stage, since AGM is required to hold for the functioning of the, my lord, board. So my lord, let departmental officer who was appointed as one-man committee, he should hold the, my lord, AGM by appointing a, my lord, departmental secretary, officer as secretary for the purpose, my lord. That's if.
No, that can be done because my lord, secretary is an integral part of the election process. Now, the dispute is with regard to the secretary. The fight is between the petitioner and the private respondent. If both of them agree, lordship may dispose it of, my lord, asking the departmental officer to file an application under section 48. Under section 48, my lord, the
48.
yes, my lord, 48. 48, my lord, the resolution is required to be sent to the government. The government will appoint a departmental officer only for the purpose of, my lord, holding the election.
Election, my lord, and board of director is authorized to appoint their secretary. So since this is a dispute regarding holding of in-charge secretary, board of director will appoint a regular secretary, my lord. If private respondent is appearing, if they
Who is for the private respondent?
in this case, my friend is right that there is a dispute between both the secretaries. Now, the petitioner, he was already arrested in connection with the case and suspended also, but be that as it may, since the election is required to be conducted for purpose of holding the BOD lordship, the department can conduct the election by appointing an officer, and once the BOD is formed, they will appoint secretary as per.
Under section 38.
Section 30. Under section
And section
authority, and they can appoint secretary, or they may take further decision regarding the post of secretary.
Board will decide, my lord.
After
Under
the-
section 38, board will decide.
Election no. My lord, there is already a division bench order asking, my lord, the cooperative society, in fact, the one-man committee to hold the election. Pursuant to that, my lord, process has been initiated, my lord.
So term will expire when?
Term already
Already
expired.
expired.
Departmental officer has been appointed. Now he will hold the election, my lord, along with the secretary.
Where is the order of the division bench?
Yes, my lord, this is the order. That will be option.
And where is the one-man committee?
One-man committee.
One-man committee to থাকিবই, board will dissolve করার পিছত। In this writ petition, perhaps, my lord, that order is not annexed.
But there is an order. Second.
My lord, in fact, your lordship will find in the order of the division bench, reference is made, my lord, to section 41(6), which relates to, my lord, one-man committee. Yeah, sir, ঠিক আছে, 41(6) ও লেখা আছে।
The next order will be the-
Yes. The order dated 14/3/2022 was passed in this proceeding.
My lord, in fact, challenge was put, my lord, by the private respondent in respect of, my lord, his termination from the board as a secretary. It's interconnected matter, my lord, though, my lord, not directly from these proceedings, my lord.
Where is that other matter? Where is the other writ petition?
That is, my lord, disposed of, my lord.
Closed, my lord.
Closed.
All other proceedings are closed, including the writ appeal, my lord. Now, in that writ appeal, my lord, the liberty has been granted to the department to hold the election, my lord. Now, election is, my lord, only for the, my lord, since the secretary is not there, or there is a dispute, my lord, the delay has occurred, my lord.
All right, we take down. Heard Mr. G.M.A. Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr. S.K. Talukdar, learned standing counsel, Cooperation Department, Assam, appearing on behalf of the respondent numbers
1, 2, 3, my lord, and 5.
1, 2,
3, 4, 5.
1 to 5. Stop. Mr. M.H. Laskar, learned counsel is present on behalf of
Respondent number 6 and 8.
respondent numbers 6 and 8. None has appeared for the respondent number 7. First time. The term in office of the executive of Kanishai dash Jabainpur Cooperative Society Limited, Karimganj, expired on
Expired on 31st of, my lord, 28/3/2022.
28/3/2022, is it?
After extension, my lord.
After extension, after the extension period.
Mm.
And therefore, but fresh election stroke AGM of the cooperative society would not be held due to ongoing dispute between the two secretaries of the cooperative society, namely the writ petitioner herein and the respondent number 8.
In charge secretary, both the in charge secretary.
Full stop. It is to be noted herein that both the petitioner as well as the respondent number 8 were initially appointed as in charge secretaries.
Yes.
But there was controversy as regards the procedure adopted for their removal
Yes.
and restoration in office.
Yes.
Full stop.
My lord will add only one thing. Pursuant to the expiry of the, my lord, board, one-man committee has come in under 41(6), my lord. That would be necessary.
It appears from the submission of Mr. Talukdar that pursuant to expiry of the term of the board of directors of the cooperative society, a one-man committee was appointed to manage the affairs of the cooperative society until such time election public AGM is held and the said one-man committee is functional till today. Full stop. After hearing the submission of both the contesting parties, this court is of the opinion that the petitioner as well as the respondent number 8 are not opposing any move to hold election public AGM of the society. Full stop. Mr. Chaudhary as well as Mr. Laskar has submitted that once the new board of directors take over charge, it will be open for them to appoint a secretary of the board, which is an internal exercise, and therefore they are not opposing the holding of the election of the public AGM of the society. Full stop. Mr. Talukdar responds by submitting that. What is your stand? That resolution?
Yes, my lord, under section 48, my lord, now the one-man committee is required to send a resolution to the government, and the government, my lord, can appoint a, my lord, official for that purpose, my lord.
Submits that as per section 48 of the Assam Cooperative Societies Act 2007, the one-man committee would be required to
Application supported by resolution, my lord.
submit an application supported by resolution of the board of the registered cooperative society for holding the election of the AGM of the society, and as and when
My
such
lord,
a
as a secretary.
Huh?
As secretary.
acting as the secretary
Ma'am.
of the board, and as and when such an application is received by the government, necessary steps for holding the AGM oblique election of the cooperative society will be initiated. Wisdom. Since there is consensus at the bar that AGM oblique election of the cooperative society is required to be held at the earliest, I am of the view that nothing survives for adjudication in this writ petition. Therefore, as agreed to by learned counsel for all the parties, this writ petition is being disposed of by providing that the one-man committee may submit application along with a resolution of the board for holding the AGM of the society
No. In
Then-
fact, for appointment of a secretary
for appointment of a secretary
to facilitate the
to
election.
facilitate the election
By
of the
developing the
AGM
government
of the society. Once such an application is received, the same be processed by the respondent number two
Yes,
My lord, it
in
will-
accordance with law.
it will be
and
very,
necessary
it will be access very much.
it will be responded one, my lord,
Be
the government.
processed by the respondent numbers 1 and 2 and necessary steps for holding the AGM oblique election of the cooperative society be taken at the earliest. The application to be submitted by the one-man committee be be placed before the competent authority within
Within, my lord, 2 weeks, my lord.
within 2 weeks from the date of
Yes.
receipt of a certified copy of this order. With the above observation, the writ petition stands.
The formation of the new union, if they may take decision relating to.
They may do many other things. Is it necessary to write it here? What is the IA?
I now have become
Infrastructure.
IA is become infectious. Then you add one more line for it. It is also submitted at the bar that at present there is no hurdle. There is no legal hurdle in holding the AGM of the AGM oblique election of the society, subject to fulfillment of the
The additional affidavit, but it has not been in the record, my lord.
Let it come up with the affidavit.
when did you file it?
My lord, on 4th of August, my lord. For it.
Mr. M. Ali, learned counsel for the petitioner submits that the additional affidavit filed by the petitioner in terms of the order dated 21/7/2023 passed by this court is not on record. As such, this matter will be listed along with the additional affidavit. Mr. D. Gogoi, learned standing counsel Forest
Forest.
Department, Assam is present and does not have any objection if the prayer is allowed. In view of the above, registry to tag the additional affidavit dated 4/8/2023 filed by the petitioner and list the matter thereafter for admission.
24, my lord, perhaps, my lord, pertains to non-payment of contractual dues.
Civil bench. It appears that
Non-payment
this
of
matter
contractual
pertains to
mention of
civil bench 4, but has been wrongly listed before this court today. Registry to verify and list the matter before the applicant.
Okay.
May it please, your lordship. Lordship, page 18, and except for may kindly be seen. Page 18, lordship.
Yes.
Payment has been released. Lordship, in this case, payment has been already released, Lordship.
I
Sanction
have
order.
to take instruction.
No. Payment has been credited to beneficiary account on 18/7/2023, Lordship.
Give the copy.
Lordship,
I'll
this is
quote
the
it.
sanction order.
Heard Mr.
R. Islam.
R. Islam, learned counsel for the writ petitioner. Also heard Ms. G. Hazarika, learned standing counsel Revenue Department, Assam, appearing for the respondent number 1,
1 and 2, Lordship.
1 and 2, and Mr. N. Goswami, learned government advocate Assam for the respondent numbers.
3.
For the respondent number 3, full stop. The instant writ petition has been filed with a prayer to direct the respondents to release the amount of rupees 74,330 due and payable to the petitioner.
This is the sanction order, Lordship.
Being the house rent of the office building of Circle Officer Lala with effect from 01/03/2022 to 31/12/2020, not 22, 2020. 1 March 2020 to 31/12/2022, 2020. Today, when the matter is called up, Ms. Hazarika has produced a copy of the order dated 28/6/2023 to submit that the amount has not only been sanctioned, but the sum of rupees 74,330 has already been deposited in the beneficiary account. Although Mr. Kansu submits that he does not have any specific instruction in that regard, yet after perusing the sanction order dated 28/6/2023, this court is the opinion that no further live issue survives in this writ petition. Therefore, by granting liberty to the petitioner to seek modification of this order, if the same becomes necessary, the writ petition stands closed. A copy of the sanction order dated 28/8/2023 be retained in the case record.
Deeply obliged. Sanction order to apply.
The three shareholder of Chidaburi Samawai Samiti, they are assailing the order of appointment of the private resident of 7 as the chairman of the board. On the ground, there is a express bar of section 37C.
If my learned friend agrees, what I'm trying to say, this matter will be closed by relegating the parties, my lord, to the register, because my lord, ascertainment of a fact, my lord, is necessary, where your lordship will not enter into. My lord, what is challenged is, my lord, there is violation of 37C. My lord, 37C says that a member or a chairman, he must not have any financial or pecuniary interest, my lord, in the society. And apparently, my lord, some documents, my lord, are annexed from where it reveals, my lord, that at the time when he tendered, my lord, the private respondent tendered his nomination, he was under some arrangement whereunder he received some profit, my lord, or my lord, commission. So therefore, to ascertain this fact and his eligibility, my lord, as a chairman, your lordship will send, my lord, both the parties, my lord, to the register. If necessary, he will make an inquiry and thereafter pass a detailed order. This is a fact, my lord, which is required to be ascertained.
So the appointment of respondent number 7 as chairman.
Chairman, my lord.
And who are the petitioners?
Petitioner is the shareholder of the society.
Yes, yes, heard Mr. P. Hazarika, learned counsel appearing for the writ petitioners, also heard Mr. S.K. Talukdar, learned standing counsel, Cooperation Department, Assam, appearing for the respondent numbers 1, 2, 3, 4,
5 and 6, my lord.
1 to 6. Mr. R. Ali, learned counsel, is present on behalf of the respondent number 7, full stop. The three petitioners herein are the shareholders of Sidhabari Gaon Panchayat Samavai Samiti Limited in the district of Walpara. They have approached this court by filing the instant writ petition, assailing the appointment of the respondent number 7 as the chairman of the GPSS on the ground that he had pecuniary interest in the functioning of the GPSS Limited, and therefore due to the bar created by section 37(c) of the Assam Cooperative Societies Act 2007, he could not have been appointed as chairman of the said society. Mr. Talukdar, learned standing counsel, Cooperative Society Assam, submits that whether the allegation made in the writ petition is correct or not would require factual verification, which would not be possible in a writ petition. Therefore, the respondent number 2, that is the Register of Cooperative Societies Assam, would be the competent authority to examine the facts and take a decision on the correctness of the allegation made in the writ petition. Full stop. Mr. Talukdar submits that the parties be relegated before the concerned authority so as to adjudicate on the aforesaid dispute. Mr. Hazarika and Mr. Ali have also fairly agreed to the said recourse. In view of the above, without expressing any opinion on the claims and counterclaims of the parties, contesting parties in this proceeding, the writ petition stands disposed of by providing that the respondent number 2 may either himself or through his nominee cause an inquiry to be made on the allegations made by the petitioners in this case against the respondent number 7, and on ascertaining the facts, pass appropriate order.
Hearing both the parties.
After hearing both the parties, first up, whatever be the outcome of the proceeding, the same be conveyed to the parties in writing. If either party feels aggrieved in the matter, even thereafter, it would be open for them, him to approach this court once again by filing fresh petition. This petition stands closed.
Lordship will fix a outer limit, my lord.
The exercise as directed by this court be carried out and completed within 6 weeks from the
My
date
lord,
of
correct.
receipt of a certified copy of this order.
Alright.
May I please, your
Last
lordship?
time we read petition.
Here, my lord, the petitioner sought some information from Agriculture Department under RTI Act, my lord. That was not given. Then appeal was filed. In appeal, my lord, what happened, my lord, I petitioner was asked to pay 6,48,000 as a photography fees. And then we file a second appeal. In second appeal, it is said only 100 pages will be given and rest I have to pay. Then subsequently, the matter was closed by impugn order. In this regard, my notice was issued to respond the Agriculture Department,
What information you want?
my lord. Here, page 22,
First of all, who is the petitioner? Page 22, what order, what information you want?
my lord, page 22. Regarding, my lord, the subsidy is fertilizer to the, my lord, different number of retailers.
So the applicant is an advocate.
Applicant. No, no,
You see page
yes, yes,
23?
yes, yes, my,
Huh?
my,
Why does he want this information for fertilizer?
that of course, my,
He
under,
is in the business of fertilizer.
that, my lord, under RT Act, my lord, the status of the, my lord, petitioner, my lord, may not be,
It is not, but 6 lakhs or free, that it will matter.
6 lakh for.
Yeah, why should somebody just ask for information involving hundreds and thousands of pages? There it will matter. Let him pay and get it.
But under this section, my lord, 7(6), if it is not given within 1 month or after 1 month, then it will be free. 7(6).
No, but if there is a huge cost involved, you think the court will not consider it?
That part, my lord, I don't know.
Then anybody will ask for any information. Give me the history of Assam from independence till today. It could be 1 crore pages. Will the
But
authority-
that should have been given, my lord, within 1 month. If within 1 month, my lord, if is asked, then my lord, I have to pay. That law has been violated.
See, the exercise must be bona fide.
That
It can't be that the law says so. I don't care. Whatever I ask, you have to give. And you have to do it at your own cost. There has to be some relevance.
that.
Why does an advocate wants this? You don't have any
That has
answer.
to- I have to.
Act may not required, but the High Court is asking you,
For that, my I have to take some.
then you file an affidavit. We want to know. We are not within the ambit of Act. So
Some
fine,
cases,
yeah.
I will like.
I heard Mr. Enhock, Learned Counsel for the petitioner. What is your stand?
Respondent number 4 and 5.
Yes. Why aren't you providing him with the information?
Lordship, we need some time to obtain instruction.
No,
File a
what time? This is going on. You are for?
For the department of agriculture.
You heard Miss
Arbora. Bora.
Bora, Learned Counsel, Standing Counsel Agriculture Department, appearing for respondent numbers 1, 2, and 3, and Miss
K. Burwa.
K. Burwa, Learned Counsel, appearing for respondent number 4, who submits that some more time is required to obtain instruction in the matter. In the meanwhile, this court has noticed that by filing the application dated 30/11/2021, the application has sought certain information. By filing the application under section 6(1), bracket close of the Right to Information Act 2005, the applicant, who is an advocate by profession, has sought information regarding the manner in which subsidized urea Inter alia, the manner in which subsidized urea were allotted to the retail dealers, to the retailers oblique dealers named in the application and for other associated information was on a query made by this court. Now, although the purpose of the application is ordinarily not relevant, here it appears that the department had projected a cost of more than rupees 6 lakhs as the price of photocopying of all documents. Under the circumstances, a query was made by the court with the petitioner's counsel as to why the petitioner, being an advocate, requires all such information. In response to the above, Mr. Hawk pays for 3 weeks' time to seek instruction and appraise this court. In view of the above and on the request of learned counsel for the parties, let this matter be listed again after 4 weeks so as to enable them to obtain instruction.
Obliged.
Item 28.
In this case, I am appearing for the respondent number 6, my lord. I have been served the copy of the reply just now, my lord. Can it be taken up?
Reply by
Reply by the petitioner, my lord.
Mr. R. Pukon, learned counsel is present on behalf of the petitioner, Mr. P. Sundi, learned counsel for the respondent number 6, submits that a copy of the affidavit in reply has been served upon him only this morning and therefore he be granted 2 weeks time to seek
Well.
instruction. Mr. N. Goswami, learned government advocate Assam, is present on behalf of respondent numbers 1, 2,
1 and 2 perhaps.
1 and 2. On the request of learned counsel for the respondent number 6, this matter stands adjourned for 2 weeks.
Much
accordingly.
Item 29.
In item 29, my morning hour, I have mentioned that matter will be taken up at 2, my lord.
2, if the other matters are over, then the court will not sit. This cannot go on. The council's convenience is not subject.
No, no, I'm not.
So you want to do it today or leave it open?
That then come tomorrow or day after tomorrow, my lord.
The day after tomorrow. On the prayer of Mr. Khatuni, and counsel for the petition, this matter is directed to be listed for motion for admission again day after tomorrow.
Obliged.
Date, yes.
Item 30.
Yes.
But I have received instructions in this matter. Prime Minister, my lord, this is not maintainable. This is for arrears of rent, my lord. Arrears of rent, recovery of arrears of rent. The writ
You want to
petition.
file affidavit?
I'll file affidavit.
Heard Mr. M. O. Mondu, learned counsel for the petitioner, also heard Mr. A. Ganguly, learned counsel appearing for the respondents who submits that he has received instructions and therefore be granted 3 weeks time to place the same on record. Prayer allowed, the counter affidavit on behalf of the respondents will file within 3 weeks by serving advance copy upon the petitioner's counsel. Let this matter be listed again after 4 weeks.
Obliged.
Item 31.
May I plead your lordship?
Yes.
My lord. Lordship, the petitioner are the elected ex-president, ex-vice president and members of the Jamatarhat Devitola Gauripur Anshalik Panchayat in the district of Dhubri, Assam.
What
They
is the
are-
case about? What is the relief?
They did not get the enhanced rent of remuneration.
Well, the case of the petitioner is that they were like functionaries under the PRIs. They have not received their remuneration, my lord, arrears. There's a judgment of the Honorable Coordinate Bench. Similar matter, my lord.
Similar matter already disposed of, lordship.
My lord, the directions given to the department are from para number 37 to 42. The covered case.
Is the finance department a party here?
In this particular case, my lord, in the judgment that I've just shared with you, finance is a party, my lord. In this case, yeah, they have made them a party, my lord.
Then where is the standing council finance? Yes, Mr. Govind.
And our names are not reflected in the list, so we have missed them otherwise.
All right, heard Mr. So-and-so.
M. Hussain. M. Hussain.
Counsel for the writ petitioner who submits that this matter is covered
Monthly remuneration.
by the judgment and order of the learned single judge dated 4/1/2023, WPC number 3662 of 2018. As such, the writ petition be disposed of. Mr. P.
Handing, my lord.
Handik Learned Standing Council PNID Assam is also fairly submitted that the matter is covered under a previous decision of this court. Mr. B. Gogoi Learned SC Finance, however, submits that since the name of the departmental council is not shown on the cause list, he has missed the matter today. On the request of Mr. Gogoi, this writ petition is directed to be listed again on 11th of August 2023, the fixed item, by showing the name of SC Finance in the cause list, so as to enable him to obtain instruction facilitating disposal of the petition. You can take this.
Yes,
You can take this, give it next.
Obliged.
I'm appearing for CGST, your lordship. Lordship, we need further 3 weeks time to file our affidavit, your lordship.
Mr. D. Sharaf, Learned Counsel for the petitioner is present. On the prayer of Ms. R. Decker, Learned Counsel appearing for the respond number.
Central government, Central General Sales Tax, your lordship, CGST.
Appearing for the respondents, this matter stands.
Lordship, 3
You have to
weeks.
tell me the respondent number. I don't know about, which is the respondent here?
Lordship,
You don't know.
I'm sorry, your lordship, I don't have.
Appearing for the respondents, respondent is granted 3 weeks time to file.
There's an interim order also.
Prayer allowed that the matter will listed again after 4 weeks. Interim order passed and they have to continue.
Item 33.
My lord. My lord, this pertains to Assam Cooperative Societies Act, my lord. The impugned order, page number 51, the last page. My lord, the case of the petitioner, who are the board of directors of the Samabay Samiti, is that, my lord. The AGM and the election was held on 28/12/2022, my lord. And they were declared as winner on the 30th of December. And so during the AGM, my lord, the one-man committee, he could not complete the agenda. And he was suspended on 12th. And there was this impugned order was passed on the same day, and the board of directors was dissolved, my lord. Now, there is no provision in this act where, because of the negligence of the one-man committee, the board of directors should be dissolved, my lord. We are elected a member after 2 years, my lord. There was no election held. We came before this honorable court. This honorable court directed an AGM and an election, and after the order of this honorable court, an AGM and election was held, and that has been dissolved, my lord. Now,
So what agenda you could not complete?
my lord, the agenda, the election was held, my lord. Can I please take you through page number till agenda 3, my lord? Everything was completed. My lord, page number 25, my lord. Page number 25.
Yes.
1, 2, 3, this has been completed, my lord. Election was held. One, two, three was.
Which agenda was not completed?
My lord,
Which agenda?
1, 2, 3 was completed, my lord. 1, 2, 3. Till 3, the resignation of the previous committee and election of the board of members. Till here it was completed. From here it was not completed because the one-man committee was absent.
Lordship, we have filed our affidavit, my lord. We have also stated that because of the access of the one-man committee, the agendas were not completed. So as per section 39 of the 2007 Act, the board was dissolved automatically. But Lordship, the order was passed by Jonel Dual Register. Lordship, may remand back to the register, he may take a call. My lord.
What call?
But
The man who has done it, he will send it back to him to take another call.
his Jonel Joint Register has passed the order, my lord, not the register.
This order is not appealable. Where is the impugn order?
My lord,
Page
page number
51.
51, my lord.
Jonel
Order is not appealable.
is available, my lord.
The order is not appealable.
My lord, we have filed a representation, my lord. Twice, my lord. We have filed representation.
Where is it? Where is it?
My lord, representation, first representation was filed on 2nd of January, my lord, page number 38, my lord. Page number 38. And the 2nd of 10th of January, my lord.
So if the one-man ad hoc committee was absent,
My lord.
who has held the meeting? AGM.
My lord, till 3 he was there. Till 3 he was there. After the election, he went off. He did not complete it, my lord. After holding the election, he was not there, my lord.
And your representation, one is
Page number 30, page number 38, my lord.
and other.
Other is the next annexure, my lord, page number 41, my lord. This is on 10th of January.
So we'll ask the register to treat your representations as appeals under 111 of the Cooperative Societies Act and pass appropriate order
My lord.
on the question of validity of the impugn order. Take the
My
card, Mr.
A.W. Aman.
A.W. Aman, counsel appearing to the lead petitioner. Lead petitioners also heard Miss M.D. Boral, standing counsel, Cooperation Department, Assam, appearing on behalf of the
1 to 5.
numbers 1 to 5. None has appeared for the respondent numbers 6 and 7. The instant writ petition has been filed by the newly elected members of
Goromari Gaon Panchayat Samabhay.
Goromari Gaon Panchayat Samabhay Samiti Limited in the AGM held on 28/12/2022, being aggrieved by the order dated 12/1/2023 passed by the Zonal Joint Register of Cooperative Societies. That is the respondent number 4 herein. Dissolving the board of directors of the society elected on 28/12/2022 and appointing a one-man committee to run and manage the affairs of the committee until and appointing a one-man committee to run the affairs of the society. The aforesaid order was apparently issued by invoking the jurisdiction under section 39 of the Assam Cooperative Societies Act 2007
My lord.
for violation of section 32 of the act on account of the fact that the one-man ad hoc committee entrusted with the holding of the AGM left the venue left the venue of the meeting without completing before completing 8 of the 11 agenda of the meeting. First up, Mr. Aman submits that although the one-man ad hoc committee had left the venue of the meeting before completing all the agenda items, yet he was present up to agenda item number 3, that is election of board of directors. And therefore, his absence in the remaining items would not have a vitiating effect on the election of the board of directors, contending that by agitating their grievance in the matter, the newly elected board of directors had submitted representations dated
2nd of January and 10th of January.
2nd of January 2023 and 10th of January 2023
My lord.
before the respondent number 2, that is the Register of Cooperative Societies, Assam. But no action has been taken on such representation filed by the petitioners. Hence this the petition. Ms. Bora Learned, SC Cooperative Societies, Department of Cooperative Societies, Cooperation Department, Assam submits that since the impugned order dated 12/1/2023 is appealable under section 111 of the Act of 2007. Hence, this matter be disposed of with the direction upon the respondent number 2 to dispose of the representations submitted by the petitioners by treating them as appeal referred under section 111 of the Act of 2007. Mr. Aman, Learned Counsel of the petitioner, has also agreed to such a recourse, but he prays for a time-bound direction. He prays for a direction to complete the process in a time-bound manner, taking note of the submission made at the bar and having regard to the facts and circumstances of the case. This writ petition is being disposed of by providing that the representation dated so and so and so and so submitted by the petitioner, writ petitioners, be treated as appeal preferred under section 111 of the Act of 2007 by the respondent number 2.
3, my lord. Raised,
Respondent number 3.
3.
2 now to 3 above. By the and the respondent number 3 may dispose of the same with a reasoned order after hearing the interested parties. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 6 weeks from the date of receipt of a certified copy. Of
The respondent should not take any consequential step.
what consequences? There is already a one-man committee.
I'm deeply obliged, my lord.
May I please?
Yes.
May I please your lordship, my lord? Here all the petitioners, my lord, 21 petitioner are the person, my lord, belong to scheduled tribe and my lord, other backward community, my lord, who are doing cultivating in a particular plot of land, my lord, last 50 years, my lord. And they have come to that particular land, my lord, due to erosion of their land in the river, my lord. And they are doing, my lord, cultivating in that particular land, my lord. And there belongs to below poverty line. My lord, one fine, my lord, morning, what happened, my lord? Without, my lord, giving any notice, my lord, we are evicted that particular plot of land. Now we are evicted that particular plot of land. Under the, my lord, right to fair compensation act, my lord, we are entitled for the compensation, my lord. That was also not done, my lord. My humble submission before your lordship is that I have submitted several representations. That may be disposed of with a, my lord, speaking order, my lord. Because, my lord, until and unless if it is not disposed of, my lord, and if they are not filing the affidavit also, my lord, matter will be pending long back, my lord. Now, my lord, stadium has been started, my lord, and it is about to, my lord, half of the work has been completed. We are not getting any either land or compensation, my lord. Either they have to give the land, my lord, or to give the compensation, my lord, alternative land. That was not done in the instant case, my lord. May I read, my lord?
Where is your representation?
Yes, my lord. Page 85, my lord. There are several representation, my lord. 93, my lord. There is a representation 7 to 2000, Annexure 7.
To 34.
Lordship, kindly come to the, my lord. Page number
So at
90.
the moment you want fair compensation.
Yes, my lord. We are asking for either alternative land or for compensation. They can decide, my lord. Because we are, my lord, landless, we are doing agriculture. That is our agricultural land, my lord. We are evicted, my lord. And as per, my lord, section 24 of the right to fair compensation and transparency land, we are entitled for the compensation. Lordship, kindly come to the, my lord. Section 24. First, your lordship come to the section 3. TN, my lord. Page 15, my lord. TN, holding of land means the total land held by a person as an owner, comma, occupant, or tenant or otherwise, my lord. We are occupant that particular plot or otherwise also. Then your lordship come to the section 24. Twenty-four put us here. 24 safe. Section given us 24 same. 24.
Yes, who is appearing for the department?
Section 24.
What is your?
As petitioners can claim that they are flood erosion and flood affected, that there is a scheme, special scheme, lordship, for rehabilitation of flood erosion people, lordship.
So let the deputy commissioner examine the remarks.
That
Heard
there is
Mr.
a committee,
NNP
lordship.
Chaudhary, Learned Council appearing for the read petitioner. Also heard Ms. Who is appearing for revenue?
I am appearing for respond number 1,
Ms.
lordship.
G. Hazarika, Learned Standing Council, Disaster Revenue and Disaster Management Department, Assam, appearing for the respond number 1, and Mr. N. S. Barua, Learned Government Advocate, Assam, for respond numbers 2, 3, and 4. Full stop. The 21 read petitioners in this petition are claim to be landless persons who are ordinary residents of the district Dhemaji. According to the petitioners,
Landless agricultural land, my lord. They have a house, my lord.
Yes, ma'am.
Claim to be the ordinary residents of district of Dhemaji. As per the case projected in the writ petition, they were cultivating plots of agricultural land under their possession and occupation so as to eke out a living, eke out a living. According to the petitioners, they were dispossessed of the said plot of land
Election number.
by the district administration for establishing establishing the sports stadium complex for the district of Dhemaji over the aforesaid land. Mr. Chaudhary submits that even if the land was required for any public purpose, the petitioners were entitled to fair compensation under the provisions of right to, within quotes, right to fair compensation and transparency in land acquisition, Rehabilitation and Settlement Act 2013, but no such compensation has been paid to them. The learned counsel for the petitioner has further submitted, next para, that the respondents are duty bound to pay compensation, fair compensation to the petitioners under the provisions of the Act of 2013, or in the alternative, provide them with equal amount of suitable cultivable land, alternative cultivable land within the vicinity. But the respondents have failed to take appropriate action in the matter, notwithstanding the representations submitted by the petitioners on several occasions, including on 11/1/2023 and
7/2/2023.
7/2023. Mr. Chaudhary has therefore prayed for a direction upon the respondent to redress the grievance of the petitioner. Ms. Hajoika, learned standing counsel, Revenue Department, Assam, submits that if the petitioners are in fact persons not having any agricultural land and are cultivators by profession, they would be entitled to apply for allotment of land under Mission Vasundhara. Is it Mission
No,
Vasundhara?
Lordship, there's a rehabilitation policy for erosion affected families of Assam 2020, Lordship. That's the scheme. Lordship.
And they are also erosion affected families. Then they would be entitled to apply for allotment of land under, yes, what is the scheme?
Rehabilitation policy for erosion affected families of Assam 2020. I will give a soft copy.
Give this of under so and so scheme of 2022. Therefore, the grievance of the petitioners will be looked into. However, the learned departmental council have submitted that they do not have any instruction in the matter. First of, since the claim of the petitioners insofar as their possession over the land in question and their entitlement to get alternative land and or fair compensation, if they have been dispossessed of if the said land has been acquired by the district administration for any public purpose, would call for factual inquiry based on the revenue records. This court is of the opinion that the deputy commissioner of the district must be directed to carry out the aforesaid exercise on the basis of the representations earlier submitted by the petitioner and take appropriate steps as may be warranted under the law for redressal of the grievance of the petitioner. The learned departmental council have also agreed to such a recourse. In view of the above, this writ petition stands disposed of by granting 4 weeks' time to the petitioners to submit a fresh representation before the respondent number. Deputy Commissioner's respondent number?
Respondent number, my lord, there.
Respondent number 2, that is the Deputy Commissioner Dhemaji, along with supporting documents establishing their claim over the land. If such a representation is filed within 4 weeks from today, if such individual representations are filed within 4 weeks from today, by enclosing a copy of this order, the matter be inquired into, and the respondent number 2 may thereafter take appropriate measures as may be warranted under the law for redressal of the grievance of the petitioners. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 6 months from the date of receipt of individual representations by the petitioners in terms of the order of this court. Full stop. With the above observation, the petition stands before them.
Give your best.
May it please the lordship. My lord, the petitioner, my lord, is operating a cement factory since 2008. My lord, on 28/4/2023, all of a sudden, my lord, the circle officer of Sonapur, he came and my lord put up a blockade. And since then, we have not been able to operate. Now, my lord, we are employing about more than 300 employees, my lord. We are paying government revenue to the extent of about 85 crores a year. So these are the background. In any case, my lord, there was an order by the Honorable Court seeking a report from the circle officer on the status of the land. My lord, before that, can I just point out one thing? My lord, in the writ petition, we have explained the schedule A and B, my lord. My lord, these are the lands. Schedule A land is about total 60 biga, 2 kotha, 3 lesa. And schedule B land is about 50 biga, 1 kotha, 18 lesa. This is 110 biga. In addition, my lord, 20 biga, 4 kotha, 9 lesa of land is under lease. Now, I'll give a little background, my lord. Prior to this, the newly implemented respondent number.
Mr. Chaudhary, what I want to, you are asking for a disposal of the.
No. I'm praying for an interim order, my lord. In fact, there was an observation by this honorable court.
Lordship may come to order dated 27.
They are supposed to submit a report, my lord.
Order dated
27/6/2020.
Yes. My learned friend is correct, my lord. In view of the observation made in para 11 of the order dated 2/6/23, the circle officer Sonapur Revenue Circle is directed to inform the court about the status of demarcation order to be carried out in respect of the government land allegedly occupied by the petitioner number 1, which was to be completed within 21 days. Then my lord will kindly come to the last but one para. Be that as it may, learned senior counsel for the petitioner has submitted that as the industry of the petitioner has been closed down, he may be permitted to resume the factory on any condition that may be imposed by the court or on the strength of an undertaking of the petitioner that they would discontinue operation of the cement factory as and when ordered. The respondents are put to notice that as to why a temporary measure until further orders, petitioner shall not be permitted to operate the factory. So my lord, my learned friend was supposed to.
Their allegation is that your client is occupying government land.
How much, my lord?
No, is that the allegation?
No. No, my lord, actually what had happened, prior to that, the private respondent number 5, my lord, they instituted a writ proceeding. It's order to put the line. My lord, prior to that, a writ petition was, a complaint was filed before the authority that a part of their land is included in our scheduled land. Now, this aspect of the matter was dealt with by this honorable court in order dated 2/6/23, my lord. If your lordships would kindly come to paragraph 8 of the order dated 2/6/23.
Yes.
Para 8. Based on the prayer made in this writ petition, the court is of the considered opinion that issue raised by the petitioner is limited to the extent that respondents should be prohibited from interfering in running of the cement factory of the petitioner, which is standing over a plot of land described in Schedule A and B and land appended to the writ petition.
Therefore, in a writ petition where prayer is to the extent of permitting petitioner number 1 to operate from Schedule A and B land, the court would only have to examine as to whether in the garb of entering into a plot of land described in Schedule A and B land, the petitioner could resume their operation on land which is not government land. The court is conscious of the fact that allegation in this writ petition is to the extent that without issuing any notice, the circle officer along with the police force had entered into the factory premises and evicted the petitioner from the government land by demolishing structures which were standing over the government land. Now, this is important. Insofar as the claim of the respondent number 5 is concerned, to the effect that land of the respondent number 5 was illegally usurped by the petitioner to set up their factory, there can be no two inferences which can be drawn up. Firstly, that the petitioners were evicted from tribal land protected under Chapter 10 of the Assam Land and Revenue Regulation by the circle officer in the guise of removing them from government land. The second possibility is that instead of evicting the petitioners from the tribal land, the circle officer had used the government power under Rule 18, 1 and 2 of the regulation to evict petitioners from purely private land. Under both the circumstances, if respondent number 5 has any claim of ownership of the land allegedly belonging to him, it would not be open to the respondent number 5 to hesitate the said claim in the writ petition filed by the petitioner as if he was making a counterclaim. In the considered opinion of the court, any claim which the respondent number 5 might have against the petitioner has to be adjudicated in appropriate forum. It is not the case of the circle officer that he was evicting the petitioner from the land under tribal bill. If that was the case, then circle officer would have given a notice to the petitioners as envisaged in law, and provisions of Rule 18 and 1 and 2 of the regulation would not be available to the circle officer. But this order has attained finality as of date, my lord. The respondent number 5 has not preferred any appeal. Now, lordship our case is, my lord, all the permissions were there, all sale deeds are there with the permission of the competent authority, my lord. We, made the purchases. Then, my lord, you were duly registered. Even in Jamabandi also, my lord, our names are shown. And from 2008, we are operating. Now, my lord,
Since when the factory operation has been stalled?
my lord, 28/4/2023. Partially, my lord. My lord, lordship knows in the process of manufacturing cement, it's an integrated process, my lord. And some raw materials are kept in a particular, then
Today, the factory is completely shut down.
completely shut down, my lord. Because since it is an integrated process, the area which is left out of the order of the circle officer, that is with us. But based on that alone, we cannot operate. It is an integrated process. That conveyor belt runs into several, length to several feet.
Now, about the demarcation status report, lordship, directed the circle officer to produce it in a seal cover. That has come, my lord, lordship will kindly peruse.
Lordship can peruse the seal cover.
Seal cover?
I don't know, it is there in the order itself.
26, you will also read para 11.
27.
Direction in seal cover.
Yes,
What is there in seal cover?
I do not understand, but it is there in the order itself. 27/6.
Perhaps that was not it. Anyway,
Perhaps.
perhaps it was not required. It does not contain any state secrets.
Seal cover is only when national security is under.
I don't know why it was. No?
So, Mr. Chaudhary, you have a look at the report. We can take it up day after tomorrow and pass an order.
That's why I also have that.
Yeah, you also have, because land matters, if you don't know what is the report, then the report passing, you also have a look. Day after tomorrow?
Could it be on Thursday, my lord?
Thursday, all right.
Thursday, no?
There is no stay order has been passed. I submit later.
I think, my lord, my learned friend has been shown the door. Better he accept that order and go away from the scene. Unnecessarily, my learned friend is intervening in this matter, my lord.
It's my life and locus in the paragraph.
No, there is an order whereby you have been prevented any further. You have been asked to go to an appropriate forum.
Before your lordship said, I cannot submit, my lord, then this carrying on. My learned.
No, I have reading the court's order. Court order says, if you have got any grievance, go to an appropriate forum.
All right.
Since it's a case pertaining to Patta land, you cannot have any grievance. If at all you have, go to civil court.
My lord, my humble submission with this factory has occupied all the land. There is a rubber, all the land has been, government land has been agreed. That in fact, my lord, earlier occasion, I categorically submit before the court. Here is the, my lord, hobnobbing is going on to the circle officer. That is why court has strictly asked to produce the report. But how can NK land, my lord, has been shelled as the executed?
You are appearing for respond number?
Hi. But there are some forces.
But Mr. K.N. Chaudhary, Learned Senior Counsel, listed by Mr. Arjit Das, Learned Counsel, appearing for the petitioner. Also heard Mr. B.J. Talukdar, Learned Senior Counsel, assisted by Mr. P.K. Mehdi, Learned Counsel, appearing for respond numbers.
Yes, my number is association.
You want, Mr. Mehdi, you know who you are. That has been a perennial problem. Government council never know who they are representing. Appearing for all the respondents. Minus respondent.
No.
Appearing for respondent number. Why you are not?
Not
appeared for
2, 3, 4.
Mr. A. Learned, Standing Council Revenue and Disaster Management Department for respond number 1. Mr. Vijay Talukdar, Learned Senior Counsel, assisted by Mr. P.K. Mehdi for respond numbers 2, 3, and 4. And Mr. N.N.B. Chaudhary, Learned Counsel, appearing for respond number 5. In terms of the order dated
27-6, my lord.
27/6/2023 passed by this court. This circle officer, Sonapur Revenue Circle, has submitted a report dated 14/7/2023 in seal covered, which was handed over to the court by the Learned Departmental Counsel. I perused the report. On perusal of the same, I find that a copy of the same must be circulated amongst the Learned Counsel for the parties, so as to enable them to respond to the same before any order is passed in the matter. As such, a copy of this report be furnished to all the Learned Counsel appearing in this case. Registry to list this matter again on Thursday, that is 10, as a fixed item for admission.
Actually, day after tomorrow, I will not be there. That's right.
Can I have my report back?
Yes, yes. Mr. Chaudhary, and you take.
My lord, in this case, my lord, 2 affidavits were filed by the respondent, the last being on 24th of July. My lord, we intend to file a reply, my lord. My clients are from Hyderabad, my lord. So, my lord, I pray that your lordship may grant me at least 14 days time, my lord.
What is this matter about?
Lordship, this is a very serious matter involving public interest, maintenance of the ICUs and all other hospital parts.
What do you
So,
have to say?
Lordship may give, because we have filed it in the month of June.
No.
It was filed in the month of June. On 16th, it was signed, and definitely in the month of June, they have received before vacation. Number 1. Number 2, Lordship, there's a public interest involved. The last vendor who was doing the job, his work was over in June. We have to extend it against all principles of law, Lordship, in public settlement.
You can give him 1 week's time.
Lordship may give them time till day after tomorrow. Let the matter be taken on Thursday. My lord, it will not be possible. My lord, in the month of June, he has made a misrepresentation
No,
report.
my
His
lord.
honor.
No, my lord, my lord. Oh, let him make the submission, Mr. Biswas. This is
My
not
lord.
the way.
There are two affidavits filed in this case. The June affidavit was received on 19th of June, 2023. The last affidavit, which is why I said two affidavits were
We
filed.
will take it up on Monday, next Monday as a fixed item.
Lordship.
Mr. M. Biswas, Learned Counsel petitioner has a week's time to complete his instruction on the affidavits filed on behalf of the department. Although Mr. D. Sekia, Learned AG Assam has expressed extreme urgency in the matter, yet considering the ground on which prayer is made, same stands allowed. This matter is directed to be posted again on Monday, next Monday, give the date, 14th of August, 2023 as a fixed item. In the meantime, the respondent, the petitioner's counsel may obtain instruction and file rejoinder if so advised. Register to verify as to whether this matter pertains to civil bench 4/5 and list the matter before appropriate. Mr. P. P. Dattal, counsel is present on behalf of respondent number 5.
Interim order may continue.
Interim order passed earlier to continue till the next date, till 14/8.
Lord, deep yours.
The loss of life by wild elephant, my lord. Here, my lord, final report submitted, my lord, regarding that, page 14 is the opinion, the doctor. And also, my lord, the postmortem report also shows that, my lord, attack.
What is to be done now? He is entitled to compensation.
As per notification.
My lord, we just seek 4 more weeks to complete the process to verify and pay.
Already
Heard
representation.
Mr. H. K. Das, Learned Counsel for the petitioner, also heard Mr.
I bought Thakur.
I. Bhattakur, Learned Counsel appearing for the respondent number.
Respondent 5,
Respondent
respondent
number
1, sorry.
Respondent number 1, Mr. S. Borwal, Learned Government Advocate Assam has appeared for respondent numbers 2, 3, and 4. The petitioner has approached this court seeking ex gratia compensation for loss of life due to attack by wild elephant, which had killed the husband of the petitioner. Mr. Bhattakur submits that 4 weeks further time be granted to verify the claim of the petitioner and thereafter process the release of compensation.
As per notification dated, my lord,
In view of
26
the
May
submission
17.
made by Mr. Bhattakur, this matter is directed to be listed again after 4 weeks. On the next date fixed, if the compensation claim is not finalized, the departmental counsel would produce written instruction indicating the reason thereof.
No problem.
Please, my lord, this matter relates to settlement of market matter. Now, my bid has been rejected on the ground of deficit of 35 rupees.
On hearing the counsel, it appears that this matter pertains to civil bench 4. Registry to therefore verify and list the matter again on Wednesday. Okay. Bid of, what is this bid of market? Is market settlement this business bench? Market settlement is this bench. Just 1 minute, market settlement is this bench. Market settlement is.
Yes.
Oh, okay.
Already,
My lord, private respondent also filed a writ petition, my lord. Already take, my lord, but that has been listed before court number 12 today, my lord.
and this matter was tagged. Now, since a new constitution tag has been constituted, that's why it has come from.
There is some.
Similarly situated.
Same, we to order. This is bench 4 matter, yes. Who is in item 40, 41?
I'm here.
Yes.
Legal lordship to restore the lordship original appeal. This was dismissed for non-prosecution lordship by order at 411 lordship. At page 12 lordship.
Heard Mr. J. Kalita, Learned Counsel for the applicant. His IA has been filed with a prayer to recall the order dated 4/11/2022 passed by this court in the connected petition by means of which, in the connected LA appeal number 9 of 2022, by means of which the appeal was dismissed for non-prosecution. Peruse the grounds stated in the application uh, explaining the default on the part of the applicant. Ms. S. Borua, learned government advocate Assam submits that she does not have any instruction to oppose the prayer made in the IA. In view of the above and considering the explanation furnished by the applicant, I am of the view that the connected appeal is required to be restored to its original file. As such, registry, as such, the order dated 04/11/2022 stands recalled. Registry to restore the appeal to its original file and list the matter for orders after 3 weeks. IS stands disposed of.
41 is same lordship,
41 also same order.
same. LA appeal number is 8.
LA appeal number is
Eight.
different.
8.
LA appeal number different. Yes,
How like?
Lordship, in
yes.
Lordship. Lord, in this case, my lord, the service is not complete, my lord. So I have to take.
In this matter, I am appearing for respondent number 3. We have filed our affidavit, Lordship, and we have also received a status report from the SP, Lordship, where it has been stated that charge sheet has already been filed. So may I pray for some time so that we can bring it on record by filing additional affidavit, charge sheet, copy of the charge.
Learned counsel for the petitioner is present. On the request of Mr. Aram Das, learned standing counsel.
No, Lordship, I am appearing for respondent number 3, private
Learned
respondent.
counsel appearing for the respondent number. He submits that there are some updated instructions available and therefore he be permitted 2 weeks time to bring the same on record.
Lordship, additional affidavit.
Mr. P. Handick, learned
569, madam.
standing counsel PNRD for respondent number 5, 6 and 9 are present, is present along with Ms. S. Borua, learned government advocate Assam for this state. On the request made by Mr. Das, this matter is directed to be posted again after 3 weeks.
Look, this matter will take some time, my lord. Whether lordship will sit in the second half or Thursday lordship can have this matter, my lord.
Yes. Alright. On the request made at the bar, this matter is directed to be posted again on Thursday. before the application.
Deep learning.
Item 44.
But in this matter, we have carried out the paper publication upon respondents 2 and 4. We need a week's time to file our affidavit. Paper publication is done for 2 and 4.
I'm on a respondent number 3.
I am for the respondent number 4. Respondent number 4.
4 is appearing the name.
4 is appeared.
Only 2.
Mr. A.
Regarding to-
Ganguly, some learned counsel for the petitioner submits that as per the order of this court, newspaper publication of notice in this case has already been made for service upon respondent numbers
2 and 4.
2 and 4. And therefore he be granted 2 weeks time to file an affidavit bringing the same fact on record. Mr.
D. Majumdar,
D. Majumdar, learned counsel is as
respondent
present
number
on
3.
respondent number 3, whereas
Sandeep
Mr.
Kumar Sudhari.
S. K. Chaudhary has appeared for respondent number 4. Ms. S. Borua, learned government advocate Assam is present on behalf of 5, 6 and 7. The registry to
Yes, sir. Direction may be given to.
registry to verify as to whether other respondents have, as to whether all the respondents have entered appearance in this case, and this the matter. With appropriate note. In the meantime, copies of the writ petition be furnished to the learned counsel for the respondents.
Lordship, this application for rectification of an error, lordship,
So we'll
date of 12/9/2021. That is the correction.
all right, take down. Heard Ms.
P. Shaha.
Shah and counsel appearing for the applicant. None is appeared for the opposite parties. This IA has been filed with a prayer to rectify a typographical error occurring in the order dated 05/06/2023, passed by this court in WPC number 1226/2018. Ms. Shah submits that in the second paragraph of the order, the date of death of the petitioner's father has been erroneously recorded as within course 12/09/2021 unquote, whereas the correct date of death ought to have been within course 12/09/2001. Full stop. After going through the record and on considering the statements made in the IA, I am of the view that the prayer for rectification of the order dated 5/6/2023 deserves to be allowed. As such, this IA is hereby disposed of by clarifying that the date of death of the petitioner's father as recorded in order dated 5/6/2023 shall be read as 12/9/2001 instead of 12/9/2021.
Lordship, another application, Lordship, there is.
Ah.
Another IA is there,
Same.
same correction,
Where is the another IA?
182.
It will be husband here.
Husband.
No, husband. Same. Just to be same. IA number 1882 of 2002 will be petitioner's husband.
Okay. Item 46.
May please the lordship. Lordship, as per laws in a court order, lordship 21/7. Notice has been deemed to serve lordship as because postal check consignment report has been going on. Here lordship, respondent number 4 and 5 is the government officials lordship. I have made a party by name, circle officer and Lord Mandal lordship. My case is that lordship, that here petition number 1 is the father. He was desired to execute a cell deed. Who is petition number 2 is the biological daughter lordship. That's why lordship. NOC applied for NOC.
Heard, Mr. Your name, please.
I have lordship.
I have learned counsel for the lead petitioner also heard Mr. A. Bhattacharjee, learned standing counsel Revenue Department Assam appearing for the respond number
2.
2 and Miss S. Burua, learned government advocate Assam for respond numbers
1 and 3.
1 and 3. Peruse the office note dated 27/2023, which goes to show that steps taken for service of notice upon respond number 4 and 5 is complete in this case. In view of the postal, in view of the observations recorded in office note dated 27/2023, the respond numbers 4 and 5 is deemed to have been served, are deemed to have been served in this case. As such, register to verify if any counsel has appeared on behalf of respond numbers 4 and 5 and list the matter thereafter in the appropriate form.
Lordship. If possible, lordship, given a date, lordship.
You come.
Highlands.
Item 47.
Millard, presently for all this, there is a IA before your lordship. That has been placed today. By this, we are praying for preponing the date of hearing of this petition. What happened here? This petition relates to an issue which involves the safety and security of the life and properties of the petitioner, as well as their nearby residents. It's under the Disaster Management Act. So orders were issued by the authority long back, asking the private respondent to implement it. They have not done it. Meanwhile, it is creating havoc. There has been further landslide in the hill. Hill was cut and the repairing was not done. And when the last occasion this matter came up, the matter was not called out in its start. So when it was called out later on, that time I was busy before this honorable court. Court fixed it for the date much after 4 weeks. But then now, because it is rainy season, it is creating serious havoc. And the danger is hanging over our head all the time. That's why we have filed this application, that it needs to be heard. And it will not take much time.
When do you want it? When?
Well, next Friday, if possible, lordship.
Next Friday?
Yes.
Next Friday means?
This Friday, my lord. Today is 11th.
No, it has to be on a non-miscellaneous day.
Non-miscellaneous day. I see. Then, my lord, in this week itself.
This week will not be possible.
Then next week, my lord,
Yes.
next week.
Heard
then-
Mr. K.K. Mahato, Senior Counsel, assisted by Ms. A. Begum, and Counsel for N Begum, learned counsel for the for the applicant to writ petitioner. Also heard.
A.S. Ali,
Mr. A.S. Ali, learned counsel appearing for the OP number
7.
7. First up, Ms. G. Hazarika, learned SC Revenue Department, Assam, is present on behalf of respondent OP numbers 1 and 1 and 2. Ms. S. Barua, learned G. Assam for respondent numbers OP numbers 2, 3, 5 and 6. Ms. R.S. Devi, learned counsel, is present on behalf of respondent number 4. This IA has been filed with a prayer seeking early hearing of the connected writ petition by contending that due to the rainy season under progress, there is serious threat to the property of the petitioner, in as much as the possibility of landslide
Yes.
in that area cannot be ruled out. Mr. Mohanto has therefore expressed urgency in the matter with a request to post this case again, post the writ petition for final hearing as a fixed item on 16/8/2023. The learned counsel appearing for the opposite parties have not opposed the prayer. In view of the statements made in the IA and the specific request made by the learned senior counsel for the applicant seeking posting of the matter on 16/8/2023. The prayer stands allowed, registered to release the connected writ petition as a fixed item for final hearing on 16/8/2023. IA stands disposed of.
Obliged.
Lordship, as per official Lazima report dated 27/23, a notice has been deemed to have been served on respondent number 5, Lordship.
Heard, Mr.
NZ Chaudhary.
N.
NZ Chaudhary.
NZ Chaudhary, learned counsel for the petition. Also heard Mr. A. Bhattacharjee, learned SC Revenue, appearing for respondent number 1, and Ms. S. Borua, learned Government Advocate Assam, appearing for respondent numbers 2, 3 and who is for 2? Respondent numbers 3 and 4. The respondent number 2 is represented by learned GA, learned Standing Council of General Administration Department, bracket GAD, bracket close Assam. Peruse the Lojima Court, peruse the Lojima Court report dated 27/2023, which goes to show that the respondent number 5 has been deemed to have been served in the matter. If that be so, this writ petition is ready as regards service and be now listed for admission.
Interim may be continued.
Interim order passed earlier. In the meantime, extra copies of the writ petition will be furnished to the learned counsel appearing for the respondents.
Much obliged.
The pleasure, Lordship. Affidavit of service will file, Lordship. For respondent number 8.
Justice Service.
Yes, Lordship.
And who you are for?
For the applicant bank, respondent number for the 8.
You are for 8. All right. Heard Mr.
KM Kakoti.
KM Kakoti, learned counsel appearing for the writ petitioner. Also heard Mr. A. Bhattacharjee, learned Standing Council Revenue Department, Assam, appearing for the respondent number
1, 2 and 3.
1, 2 and 3. Miss S. Borua, learned Government Advocate Assam, and Miss S. Borua, learned Government Advocate Assam, appearing for respondent numbers 4, 5 and 4, 5, 6 and 7. Miss, your name?
M. Bose. M. Bose.
M. Bose. Full name, full name?
Moumita Bose.
Miss Moumita Bose, learned counsel, is appeared
On behalf of D. Banerjee, learned counsel.
respondent number 8, and submits that she, along with her senior, Mr. D. Banerjee, has been engaged in this case by the respondent number 8. Learned Counsel for the petitioner has invited the attention of the court to the affidavit filed on 24/7/2023 after effecting dusty service of notice on respond number 8. Since the respond number 8 has entered appearance, he said aspect of the matter need not be gone into at this stage. Registry to list this case after 2 weeks for admission.
Interim may continue.
Interim order passed earlier to continue till then, after 2 weeks.
My lord, today fixed for instruction, my lord, and this the matter pertains to, my lord.
Yes.
No, we are the board members, my lord, Kapanchad members. We brought requisition against the respond number 8. According to the secretary has followed all the terms as per the section 15(1), my lord. But what happened, my lord, ultimately, the president, as per 15 days failed to continue meeting, then shifted to Anchalik Panchayat. Anchalik Panchayat also not held. Accordingly, meeting requisition placed before the deputy commissioner. But in this case, the Deshi, my lord, instead of holding meeting, my lord, that shifted burden to the secretary that he failed to comply the time limits of the section 15(1). And
Yes, what is your instruction?
My lord, we have not received any instructions till date, my lord. My lord, but as per section 15, my lord, the DC can very well fix a date and convene the meeting. The impugn notice is at page 24.
No, then we'll fix it on Monday. You get the treated.
I'll get the.
Heard Mr. P.K. Dekar, Learned Counsel for the writ petitioner, also heard Ms. P. Hendik, Learned Standing Counsel, PNRD Assam, who submits that although instructions are still awaited, yet as per section
15(1), my lord.
15(1)
DC has the authorization.
Assam Panchayat Act 1994, the deputy commissioner of the district has the power and jurisdiction to declare a date for holding
Convening a meeting of no
convening a-
confidence motion.
the deputy commissioner of the district has the authority and jurisdiction to convene a meeting
yes, my
for
lord.
discussing the
Meeting, no
confidence.
confidence motion.
no confidence
Against
motion
respondent number 8, president.
brought against the president of the Gaon Panchayat, that is the respond number 8. Mr. Hendik prays for one final opportunity to obtain
My lord.
written instruction in the matter with a request to post this writ petition again on 14/8/2023 as a fixed item. Prayer allowed. This is the case again on 14/8.
Lordship.
Part two. There is a reference also to it.
Reference, my lord.